No, that is one aspect. Now, have you got the paper book?
My lord,
I have the paper.
Huh? You collect it today, and then we'll have the hearing.
This
We'll
is what
complete
is
it.
provided.
We'll have the hearing. That is what the
Hearing-
Supreme Court has said
Yes.
early hearing.
Hearing
We'll
should
fix
be-
it for the after tomorrow.
Gotcha.
day after, my lord, maybe next week then. Maybe next week,
Okay,
Next.
whenever.
Monday, Tuesday.
Uh-huh.
Monday, 24th.
So you'll be collecting it today.
24th is that bomb blast case is fixed. 24th, that is next Monday.
Ah.
That bomb blast case is fixed. So maybe after that, maybe Tuesday or
25th. Can be.
We can fix it 25th.
Or
NDNPS.
if I-
NDNPS is the very limited.
if I,
Basically 52A and
Exactly,
that
madam.
only 52A is your case, I think.
one point, my lord, 1 point on the bail application. I had given a government notification of 2010 that should be in the pipe.
Huh? Look, we are ready to hear this matter tomorrow. also.
Not for that matter, some other, because there's an issue, there's a thing that says that people who are positive, HIV positive or AIDS, and they are in jail, they should be kept in jails which are nearer to their place, native.
No, that will decide. You see that we are not on that.
No, my lord, what I'm saying-
We'll leave the matter Friday also.
My
No
lord,
problem.
that's what, for hearing, I'm okay. What I'm saying, is disposing the bail, if your lordship gives an observation. that
No,
we
no,
may-
we're not disposing of anything today.
Okay.
We're not disposing of anything today. We are, or we can dispose of the bail also.
With a direction that we may approach the concerned authorities for a transfer to to jail next to our place.
Under
we
the
can go-
Assam Jail
no,
manual, under the Assam Jail manual, what I have found is people with infectious disease should be kept in isolated rooms.
Huh.
Now,
But-
whether AIDS come within that.
It's not an
definition,
infectious disease.
Ah.
AIDS is
Can
not an
be
infectious disease unless you are a needle, you share needles or you have some sexual contact.
Mm,
Otherwise, it's not like hepatitis
yes.
or tuberculosis or something like that. It's nothing like that.
In
What I'm-
Uttarakhand case, I found that there were around 15, 16 people who were infected with AIDS. They were in the jail.
You see, we are not
And
going to
then-
give you any advices. You go if you think that you come within the provisions of this.
Yes, madam, the page 3,
document.
if your lordship comes to page 3
Page
of the
3.
document,
Yes,
point I, subclause I.
yes.
Now, the correctional needs of such prisoners are also different, as it is not just social disintegration which relevant, but there is a need for psychological, spiritual support and adequate human contact to help them
Look,
maintain the mental health.
we are
No, madam, the
anyway.
last point.
Yes.
TIPs, that is terminally ill patients, should therefore be placed as close to their homes as possible to enable regular visits from the families and members and friends. Now, issue is he's a Manipuri guy. He's from Manipur. He's lodged in Morigaon jail.
And he comes and commits a crime in
My
a
lord,
SAP.
that's a
Ah,
separate
yes.
issue, my lord. This is for criminals only. Government has issued this for criminals only.
You go there, you go to the court,
Only
you go to the government.
my only prayer before your lordship is, if an observation can be made that
No,
I
no,
can-
no, no, no. When we are disposing of the
Ah,
main appeal,
Yes.
we're not going to that issue.
Okay, ma'am, the next week, the main appeal next week.
Main appeal will be next week whenever. This bail will dispose it of today. Right. Heard, Mr.
DK Bhattacharya.
D.K. Bhattacharya, learned counsel for the applicant. In which case, in item number?
11.
I-
Ah.
In criminal appeal number 10 of 2023. But your thing is not here, your name is not here.
My lord, I am in the IA. I have been, if a lordship takes my, I'm just engaged for the IA.
Oh, you are only
Otherwise-
engaged for the.
IA. 23, there's a legal aid council.
Okay,
I
so
can
you're not
send
even, he's not engaged in 11.
Yes.
This is in 10.
10.
Only IA.
But the
Just-
common judgment. 10 and 11 is a common judgment.
Maybe.
11, Paul is there, J. Paul.
Okay, what have you said? Heard, Mr. Bhattacharya, learned counsel for the applicant
Hmm.
in IA criminal 464/2023 arising out of criminal appeal number Criminal Appeal bracket J. 34/2023. Pushpa. Miss, yes, Miss J. Paul. What about Miss Dipanjali D.
She is the legal aid counsel. She was here this morning. She is a legal aid counsel in item 10. She will be doing the matter.
She
I'll be
comes
assisting.
regularly today. I don't.
But she should be, let her be here. Today is the matter. Let her be here. No, we want her. We want her presence. Just call her. We want her presence. We want to clarify everything. Let her be here. Next. Oh, no, that is a different thing. Now, next. Let her come.
Yeah.
Yes. Dying declaration
Dying declaration,
recorded by doctors,
carbon copy
and then the family also separately they have been
or a
uh
dying declaration.
now what remains? Can you tell us? So what is your case?
Mother, the dying declaration that was recorded by the doctor, the original has not been produced.
Original has not been produced.
It has not been.
Just a minute. Dying declaration. How do you say that it has not been produced?
Because the exhibit 1, it's a carbon copy. The
It's a, exhibit 1 is a,
is the dying declaration.
Dying declaration, page
let us page.
55.
This one. Ah. Page 55.
Page 55.
So you say that this is, let us see the record. Yes, sure. So, is it the original has been produced or not? Just see, just see.
PW1 and PW5. They have themselves said that exhibit 1 is the carbon copy.
PW
PW1
1
and 9, PW9.
Have stated that
The exhibit 1 is a carbon copy.
exhibit 1 is page 55.
Page 55.
Yes, madam.
Lordship, exhibit 1, yes, it's an, seems to be like, yes, my lord, but whether it's a photocopy or carbon copy, Lordship will kindly have a look at it. Looks like it's a carbon copy.
No, but how does it, so if
Yes,
it's a
how
carbon
does it-
copy, how does it matter?
First point, sir. The second point is that there is no declaration.
Yes, all the authors have Lordship proof the veracity of the dying
Signatures are
declaration.
original.
Signatures are original.
Signature is
Yes.
original. How does it matter?
I'll place. I'll place. The second.
And authors of the dying declaration, they have proof, they have Lordship, they have been testified.
Second point is that there is no certificate by the doctor that the victim was in a fit mental condition to give the dying.
Evidence is there.
Madam,
No certificate.
no certificate.
No certificate that
The victim, the person who gave the dying declaration was in a fit mental condition to give the.
yes.
My first leg of argument, apart from this on merit,
is that I have been convicted under 302. The charge was framed under 304B and not 302.
Okay,
There is an omission in framing of the charge.
charge framed under section 304
B,
B,
dowry debt.
convicted under 302.
302. There is a clear finding of the learned trial judge that dowry has not been proved, could not be. There is
What
no
was not proved?
dowry,
Dowry,
demand for dowry,
demand for dowry not proved.
not proved. So 304 is ruled out. 304B is ruled out. However, I've been convicted under 302 without any charge.
Without any charge being paid. Any citations in support of your submission? Anything else? Any other point? That's all.
These are the main.
Just should us. Just give us the, just give us the citation. How is it better without the glass? Better. Which one?
It's two glasses.
This side one? No, the,
Even this.
acha, this one. You want this
cannot
removed?
mirror the other side.
Ah, okay, okay. You tell them to remove the glass. Let the barrier remain, but the glass, otherwise they'll fight.
The first citation is matter 2010, volume 10.
For which
For
point?
the purpose omission in charge, effect of
Okay, okay, omission in charge. 2010,
2010, volume 10 SAC, page 130,
130, para
para 20 to 25,
22 and 25.
20 to 25.
20 to 25, okay. Yes,
Paragraph 20, madam. When the accused is charged with having entered the house of Prakashi Devi and assaulted the said Prakashi Devi with the intent to outrage her modesty, and when the accused defended himself in regard to the state charge and concentrated on proving that the state charge was not true, he cannot be convicted for having assaulted and outraged the modesty of someone else, namely Sheila Devi. So in this case, the charge was
that is a different thing. That's a different issue.
no, the accused did not have the opportunity to meet or defend himself against the charge that he has assaulted Sheila Devi and outraged her modesty. In my case, 302. I did not have the opportunity to defend myself for 302.
Okay, the facts here are different,
Facts here are
completely different.
completely different, but the law point, I'm placing the law point. Further, nor did he proceed with his defense on the understanding that he was being charged with having committed the offense with reference to Sheila Devi. One of the fundamental principle of justice is that an accused should know what is the charge against him so that he can build his defense in regard to that charge. An accused cannot be punished for committing an offense against Y when he is charged with having committed the offense against X.
This part is not relevant.
An accused cannot be punished for committing an offense against Y when he is charged with having committed the offense against X, and the entire defense of the accused was with reference to charge of having committed offense against X. 21. The illustration under the provision of the statute offer relevant valuable indication as to the meaning and object of the provisions and are helpful in working the application of the provision. Illustration E of section 215. Allowed from 211 of CRPC. It relates to charge, how it should be framed, contents of the charge, particulars as to time, place, and person, effect of errors are relating to section 211 to 215.
Yes,
Fine.
this is not on the point.
My lord,
Anyway,
I'll place 211 of CRPC. my lord.
Huh?
211.
211.
Fine.
Section 211
11
CRPC.
CRPC.
Yes,
My lord, it says contents of charge.
yes,
One, every charge under this code shall state the offense with which the accused is charged. Two, if the law which creates the offense gives it a specific name, the offense may be described in the charge by that name only. Three, if the law which creates the offense does not give it in any specific name, so much of the definition of the offense must be stated so as to give the accused notice of the matter with which he is charged. Four, the law and the section of the law against which the offense is said to have been committed shall be mentioned in the charge.
yes.
And 213, madam, sorry, madam.
Third section,
My lord, 218, my lord. Separate charge for separate offenses. For every distinct offense of which any person is charged, there shall be a separate charge, and every such charge shall be tried separately. Provided that where the accused person by an application in writing, so that's not required.
we understand your, what you're trying to say, but it's not exactly hitting the point. You see, there can be an alteration of charge,
It can
or
be
you can
altered.
be convicted
It
of
can
a
be
lesser
altered.
sentence
It could have been altered any.
on a thing, but then, since this is the gravity of the charge is more, it appears that they should have been, he should have been charged, there should have been alteration of charge, or should have been given a chance to rebut. I don't know what you have got to say to that. Hello, Ante. Hello.
Remanded for private charge. 302 and 304.
Already there.
Will be on
So it's 304. 302 has to be added. That's what, but. that's not the correct definition. It is. There is a. I have computer, I have it. That's all. Anything else?
My lord, the effect 464 CRPC.
464. Yes,
Effect of omission to frame charge.
yes,
No finding, sentence, or order of a court by a competent jurisdiction shall be deemed to be invalid merely on the ground that no charge was framed, or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charge, unless, in the opinion of the Court of Appeal, a failure of justice has in fact been occasioned thereby.
yes. Anything else?
If such is the opinion of the appellate court, then it would be remanded.
Remanded back for, yeah,
There is a proviso.
Yeah.
There is a proviso.
yeah, it says,
The proviso says that if the court is of the opinion that the facts of the case are such that no valid charge could be preferred against the accused in respect of the facts proved, itself was the conviction.
but out here, there is
So I'll
there
place
is a dying declaration.
On those, I'll place on decision, man. On the tank.
But if you go to that extent, supposing we hold that the dying declaration is, there is no infirmity, and what would be your chance before the learned trial court? If you want us to decide that aspect of the matter. You think about it, otherwise, anyway, it's up to you.
Right.
Because once you go into the question of dying declaration, where a doctor, in fact, not one doctor, there were three doctors, one written down and there were two other witnesses. And they have all stated that he is competent to give his dying declaration. Now, if you want
The
us to,
victim was conscious.
Huh?
They have stated that the victim was conscious. They have
Correct.
not stated that the victim was in a fit mental condition to give their statement.
okay, I don't know, whatever, but if you want to, you please think over a little bit.
Right.
Supposing we come to a finding that, because what you're trying to say is that the dying declaration could not have been acted upon. And accordingly, this has to be acquitted. Now, supposing we come to finding, no, it could have been acted upon. There was nothing wrong with the dying declaration recorded by the doctors. And what would your fate be before the learned trial court? It's a double-edged sword if you're going to go on that aspect. You're basically, because that is your only obstruction or obstacle in your path for acquittal. Now, if we decide on that aspect, charge is framed under 302, and that aspect of dying declaration is decided in your favor, then it's okay. If it's not in your favor, then what happened?
I'd like to place matter 2022, volume 4 GLT,
2022,
volume 4 GLT,
volume 4 GLT,
page 45.
page 45.
Similarly situated case.
But there's a Supreme Court judgment also. I hope you know that.
Those have been relied there.
Okay.
Those have-
Yes,
Are placed from paragraph 5, madam.
paragraph 5. Okay.
The prosecution case is basically based on the dying declaration of the victim. In order to bring home the charge, the prosecution has examined as many as 7 witnesses, including the doctor who had conducted the postmortem examination on the dead body and the IO who had conducted the investigation. The prosecution has heavily relied upon the oral dying declaration of the victim brought on record by PW2 and 5. In our case, PW2, the victim's sister,
The
Yes.
parents of the victim,
madam,
2 and 5, the parents
2 and
of the
5.
victim.
I'm saying about the present case, madam. In my case, in the appeal before your lordship, PW2, sister of the victim. She
In
has
in
given-
this case, the doctor has specifically opined, given evidence.
the so and so, that is the parents of the victim as well as the dying declaration recorded by the IO. In our case, the doctor has recorded the dying declaration.
It's a
In this
oral
case,
dying
the IO had
Huh?
recorded. it.
Oh. Out here, this is an oral dying declaration, mind you.
Huh.
Out here it is recorded.
There are 2 dying declarations here, one oral and one written.
Mr. Counsel, I don't know if if you understand if you understand the import of what we are trying to convey to you.
I'm estimating-
But if you're still adamant on going in that path, then because there is, you see, out here it is recorded. It is not an oral dying declaration. It is recorded by doctors, 3 doctors in fact. They were all there. And it is written down in writing. In this judgment, it is an oral dying declaration which has been made by the parents of the deceased. But in our case, they are independent persons, doctors. Anyway, if you want to carry on this path, we'll hear you. But remember, you are basically maybe closing the door. Even if we remand it back, the end result may end up. I do not know. Up to. So think about it. I hope you understand what we're trying to say.
Madam, I have
Because if you now go along this path, straight away there's a difference. Out here, there's a written dying declaration recorded by 3 doctors. In this case, which you're trying to rely upon, it is an oral dying declaration which has been uh, made by by the victim to the parents,
Parent.
and the parents are trying to prove it.
In my case, oral evidence was being proved by the PW2, the sister of the victim.
Slightly different. Very different. Yes. Anyway. Yes, then.
Madam. Well, uh, in this judgment, madam, the dying declaration was recorded by the IO PW6 as Exhibit 4, so as to prove that it is none other than the accused who had set the victim ablaze with the intention to kill her. After recording the evidence of the prosecution witnesses, the statement of the accused was recorded under Section 313 CRPC. While denying all the incriminating circumstances put to him, the accused had also stated that did not set his wife ablaze and also did not know how his wife had caught fire. But when she screamed, he tried to save her. The defense side, however, did not adduce any evidence. On conclusion of the trial and on 11.
Which para are you reading?
Paragraph 5, my lord.
Sorry, where? On conclusion of the trial.
On conclusion of the trial and on evaluation of the evidence brought on record that learned trial court had convicted the accused appellant under Section 302 IPC and sentenced him as a proceed. Paragraph 6, madam. By referring to the materials available on record, Mr. Gupta, learned amicus, has argued that the oral dying declaration were brought on record by PW 2 and 5 for the first time during recording of their evidence, and hence their testimonies on such count were not believable. Insofar as the dying declaration recorded by PW 6 is concerned, here also submits Mr. Gupta, there is no opinion of the doctor certifying that the victim was in a fit state of mind to make such statement. Mr. Gupta has further argued that neither any doctor nor magistrate has recorded the dying declaration. This is not the case in our mind. But he has relied on Papar Kamba Rosamba, reported in 1999, 7 SCC 695. I'll place it later on. And that's Supreme Court decision, my lord. Nineteen 7 SCC. Relating to certificate of fitness matter. Paragraph 8, my lord.
Yes.
The main question is as to whether she was conscious and was in a fit mental condition to make a voluntary disclosure of the incident. Dr. Suenso, who was attached to Tenali Government Hospital, examined Sri Suenso on 4/3/94 at 1:30 p.m. She then sent a requisition to the magistrate to PW 13 to record the dying declaration of the injury. All that Dr. Suenso has stated is that the injured was conscious, but she has not deposed that the injured was in a fit state of mind to make a statement. It has come on record that the injured that Srimati So-and-so had sustained 90% of burn injuries. PW 13, who had recorded the dying declaration, has made a note in exhibit so and so dying declaration after putting some preliminary question to the injured, and it reads as under. On the basis of the answer elicited from the declarant to the above questions, I am satisfied that she is in a fit disposition state of mind to make a declaration. The magistrate has written it, but there is no certificate by the doctor. Thereafter, the learned magistrate proceeded to record the dying declaration. At the end, PW 10 has appended a certificate saying the patient is conscious while recording the statement. Similar in my case. The question that needs to be considered is as to whether the magistrate could have come to a definite conclusion that the injured was in a fit state of mind to make a declaration in the absence of a certificate by the doctor certifying that the state of mind that existed before recording the dying declaration. In our opinion, in absence of the medical certification that the injured was in a fit state of mind at the time of making the declaration, it would be very much risky to accept the subjective satisfaction of a magistrate who opined that the injured was in a fit state of mind at that time of making declaration. It is a case of circumstantial evidence, and only circumstances relied upon by the prosecution is the dying declaration. And for a moment, if the lordship may come to cross-examination of PW 9, who had recorded that dying declaration matter at page 26 of the paper book.
Page
26 of the paper book.
yes.
I'm relying on the cross matter at page 27. Police did not record my statement during investigation of the case. It is not a fact that my statement was recorded so and so. I stated before the police that the patient suffered around 99% burn injury. In exhibit 1, carbon copy of the dying declaration of the deceased, there is no endorsement that after recording the dying declaration is what it was read over to the maker. It is recorded in English, and but it is spelled out in Assamese matter. In the said exhibit, it is not been specifically mentioned that during the relevant time, the patient was in a fit condition to give her dying declaration. However, in the report, it has been clearly mentioned that at the time she was fully conscious to give her statement. The question put to the patient were in Assamese language, and her answers were thereafter recorded by me in English language in the aforementioned exhibit 1. Whatever he had recorded, he did not again read over to the maker to confirm whatever he has written is correct or not. It was in a different language. Coming back to the Supreme Court decision matter 1999-7,
Yes, yes.
paragraph 9.
Paragraph,
Paragraph 9. I placed paragraph
9.
8. I placed
Yes.
paragraph 9 and 10. It is true that the medical officer PW 10 at the end of the dying declaration had certified patient is conscious while recording the statement. It has come on record that the injured so and so had sustained extensive burn injuries on a person. PW 9 who performed the postmortem report stated that the injured had sustained 90% burn injuries. In this case, as stated earlier, the prosecution case solely rested on the dying declaration. It was therefore necessary for the prosecution to prove the dying declaration as being genuine, true, and free from all doubts. And it was recorded when the injured was in a fit state of mind. In our opinion, the certificate appended to the dying declaration at the end by Dr. So-and-so did not comply with the requirement in as much as she has failed to certify that the injured was in a fit state of mind at the time of recording the dying declaration. The certificate of the said expert at the end only says that the patient is conscious while recording the statement. In view of this material omission, it would not be safe to accept the dying declaration as true and genuine as made when the injured was in a fit state of mind. From the judgment of the courts below, it appears that this aspect was not kept in mind, and resultantly, they erred in accepting the said dying declaration as true, genuine, and made when the injured was in a fit state of mind. In medical science, two stages, namely conscious and a fit state of mind, are distinct and are not synonymous. One may be conscious, but not necessarily in a fit state of mind. The distinction was overlooked by the court. Paragraph 10, ma'am. Apart from these three lacunae mentioned here in above, we find some more infirmities in the dying declaration. In the dying declaration, so and so stated that A1 to 3 poured kerosene on her, and thereafter she also poured kerosene on herself. Maybe may not be relevant, madam. May not be relevant.
Then it's different.
That is
She
different.
said she poured kerosene on herself.
8 and 9,
So that's why they didn't believe. So these facts are different.
not entirely different, madam.
Anyway, yes.
But the certification is not there, madam.
In judgment, paragraph of 20.
Oh.
It's written that part was even taken that the practice of the civil of 14 as well as.
Because if your lordship will see the FIR by PW2,
Let's see the charge stream of
Madam.
The charge it down. But in
Page 7,
judgment, subsequently charge it.
charge under one head,
Just a minute.
madam.
That was the people of the-
Charge is very clear as with regard to 304.
Subsequent discharge was there. 18 330. 204, the accused of the matter addition charge 304 as per direction.
That is
It is-
18/3/20.
18 330.
Yes.
Madam, the inquest report also your lordship will see at page 71, madam.
Page 71.
71. Relevant, I will place 74, my lord, page 74. G,
71 or 74?
71, it starts relevant, I'm placing at page 74. The first line, G, position of limbs, eye and mouth relates to description of the corpse to be recorded after close observation of all parts of the body in good light. G, it says limbs burnt, eyes, mouth, all burnt.
Mouth open.
She was 75 to 90%. She was burnt. Different person at different places have stated differently, but up to 90% they have said she was burnt. And if I may also place the paragraph 9 and 22 of
Just
the
a minute,
judgment.
just a minute. Yes, anything else?
Paragraph 9 and 22 of the judgment, impugned judgment, page 43,
Page 40?
paragraph 9.
Paragraph 9.
Paragraph 9. PW 10, the investigating officer, page 43.
Yes,
PW 10, the investigating officer who recorded the statement of PW 2 under section 161 CRPC stated that PW 2 did not state before him regarding demand of vehicle or establishment of any shop for the accused. PW 2 also did not state before him regarding demand of rupees 10,000 for treatment of Guru Parika. The scrutiny of the oral testimony of PW 2 vis-a-vis his previous statement before the police as confirmed to PW 10, as well as in Exhibit 2 FIR lodged by the PW 2 transpires that he has not stated in his previous statement regarding the demand for any vehicle or establishment of any shop for him or demand of rupees 10,000 for treatment. In the FIR, PW 2 has made a general statement that the victim was subjected to physical and mental torture and huge amount of money was paid to him without referring to as to who demanded the money and when demanded such money and or to whom such money was paid. There is also no mention in the FIR regarding the accused demanding for vehicle establishment of shop, and therefore, for the first time, PW 2 is found to have stated regarding demand of money in court. That apart, the statement of PW 2 with regard to payment of money to the accused seems to be a self-contradictory, as much as in one breath, he told that he paid all money for treatment, and in the next breath, he told that money would be paid as and when Bulu is hospitalized for delivery. Besides the evidence of PW 2 in court, there is no other evidence with regard to the demand of any dowry. Even if it is assumed for argument's sake that the accused suggested the PW 2 being elder brother of the deceased, requesting him to bear expenses of medical treatment, that cannot be considered as demand for dowry, inasmuch as the term dowry as defined in Dowry Prohibition Act implies that it must be related to marriage. May that estimate true when the PW 2 nowhere in his previous statement stated about such demand for vehicle or rupees 10,000 for treatment or demand of establishment of a shop. The evidence of PW 2 for the first time in court does not appear to be worthy of credence and reliability. And the conclusion is in paragraph 22.
paragraph
22, page 50.
yes,
The charge has been framed against the accused under section 304B as well as 302. Although it is written here 302, but I have now not found anything.
it is there in the order dated 18/3/2013.
18/3/2013. The charge was altered.
Not altered, not altered, added,
Add-
additional charge.
In order to constitute an offense under section 304B IPC, prosecution need to prove that death of a woman was caused by burn or under any unnatural circumstance. Death is within 7 years of marriage. And 3, the victim was subjected to cruelty and harassment by the husband or the relatives of the husband for dowry, for demand of dowry, soon before the death. In the instant case, the evidence discussed herein above clearly established that death of the victim was caused due to burn injury, and such death was within 7 years of her marriage. But there is no cogent evidence on record to show that the victim was subjected to cruelty or harassment by the husband or relative for demand of dowry. Although PW 2 stated in our evidence regarding demand of money from the evidence of PW 2 as discussed herein above, it is abundantly clear that his testimony with regard to the demand of dowry is not at all believable. There is also no evidence with regard to the harassment and cruelty by the husband or relative on demand of dowry. Therefore, in absence of evidence that the victim was subjected to cruelty or harassment for demand of dowry soon before the death of the victim cannot be called a dowry death, inasmuch as even a presumption under 113B Evidence Act in the facts and circumstances of the case cannot be taken in the instant case. So 304B is ruled out. Now, as regards that 302 matter, I've come back to 2022, volume 4 GLT, page 45. Let me reline.
Yes,
Paragraph 7.
yes.
As an alternative argument, the learned amicus has submitted that even if it is held that the accused was responsible for the death of his wife, even then, the materials available on record clearly indicate that there was a quarrel between the accused and his wife immediately before the occurrence. As such, it is evident that the incident had taken place due to grave and sudden provocation without any premeditation on the part of the accused. In my case, there is no such thing, no quarrel, nothing. He submits that there is nothing on record to show that the accused had any intention to cause death to the deceased, and therefore his conviction be converted to one under section 304 part 8, so and so. Paragraph 8, madam. Responding to the above argument, the learned PP submits that the oral dying declaration of PW 2 and 5, the related mother and father, finds due corroboration from the evidence of PW 6. The PW 1 has also deposed that he had heard the victim saying that she was set ablaze. Therefore, it could not be said that there was no corroborating evidence in support of the dying declaration brought on record by the prosecution. The learned PP, however, submits that even if the dying declaration are ignored by this court, even then, the evidence brought on record clearly establishes all the links and the chain of circumstances so as to prove the incident took place inside the house of the accused, and he was present in the house at that point of time. She submits that the explanation furnished by the accused while recording his statement under section 313 CRPC does not find support from the evidence on record, and therefore it is clear that the accused has failed to offer any plausible explanation in discharge of his burden under section 106 of the evidence. Under the circumstances, submits the PP, the charge brought against the accused under section 302 stands fully established by the circumstantial evidence. On such ground, the learned PP has prayed for dismissal of the appeal.
Anyway, I think that is your basic case. Basically, your basic case is that he has no certificate has been issued that the deceased was in a fit state of mind.
Right.
That is your basic
That
case.
finding is in
That is
paragraph
your
19 and
basic
20. Right.
Yes, what is-
Referring to judgments, one on error on framing charge and one.
no,
with-
framing of
Yes,
charge
it
is
just
the same.
added subsequently, so that
that
he
is about-
is gone.
Yes.
So other aspect, your lordship, when two doctors and one casual officers of the GMC, Guwahati Medical College, endorsed that the dying declaration was recorded, and the doctor who took the dying declaration, PW 9, my lord, he deposes before the court that she was in a fit state of mind. May I
No,
state
no,
with
when is it a fit state of mind?
Yes, your lordship, evidence of PW 9, my lord.
Right?
Lordship, he states like she was conscious, my lord, is page 27.
That is
She
what
was
conscious-
conscious.
No, that is why he's
Yes.
reading out.
Yes,
That-
whether it's sufficient, my lord. So that aspect I am referring on judgment, constitutional bench judgment,
Okay, very
my
good.
lord. But I have got only one copy. Here's
Okay,
another one.
okay, one copy will
That's
do
fine, my-
for the time being.
May I take the Xerox copy? 3,000. I'll slowly read out, your lordship. Sorry, to not give the book list. 2002 5 Supreme 557 is the same citation, my lord. Laxman
2002.
2 5 Supreme 557. It's reported in
This-
2002 6 SCC 710.
Sarah?
Lordship, I'm referring to your lordship, para 3, 4, and 5. I'm slowly reading out your lordship. Para 3. The juristic theory regarding acceptability of a dying declaration is that such declaration is made in extremity when the party is at the point of death and when every hope of this world is gone, when every motive to falsehood is silenced, and a man is induced by the most powerful consideration to speak only the truth. Notwithstanding the same, great caution must be exercised in considering the weight to be given to the species of evidence on account of the existence of many circumstances which may affect their truth. The situation in which a man is on deathbed is so solemn and serene is a reason in law to accept the veracity of his statement. It is for this reason the requirements of oath and cross-examination are dispensed with. Since the accused has no power of cross-examination, court insists that the dying declaration should be of such a nature as to inspire full confidence of the court in its truthfulness and correctness. The court, however, has to always be on guard to see that the statement of the deceased was not as a result of either tutoring or prompting or a product of imagination. The court also must further decide the deceased was in a fit state of mind and had the opportunity to observe the identity of the assailant. Normally, therefore, the court, in order to satisfy whether the deceased was in a fit mental condition to make the dying declaration, look up to the medical opinion. But where the eyewitnesses state that the deceased was in a fit and conscious state to make the declaration, the medical opinion will not prevail, nor can it be said that since there is no certification of the doctor as to the fitness of the mind of the declarant,
Just a minute, that's what.
now she may proceed.
Yes.
Since there is no certification of the doctor as to the fitness of the mind of the deceased, the dying declaration is not acceptable. A dying declaration can be oral or in writing, and any adequate method of communication, whether the words or by signs or otherwise, will suffice provided the indication is positive and definite. In most cases, however, such statements are made orally before death, ensues and is reduced to writing by someone like a magistrate or a doctor or a police officer. When it is recorded, no oath is necessary, nor in the presence of a magistrate is absolutely necessary. Although to assure authenticity, it is usual to call a magistrate, if available, for recording of the statement of a man about to die. There is no requirement of law that a dying declaration must necessarily be made to a magistrate, and when such statement is recorded by a magistrate, there is no specified statutory form of such recording. Consequently, that what is evidential value or weight has to be attached to such statement necessarily depends on the facts and circumstances of each particular case. What is essentially required is that a person who records the dying declaration must be satisfied. The lordship will kindly note that part. What is essentially required is that a person who records a dying declaration must be satisfied that the deceased was in a fit state of mind, where it is proved by the testimony of the magistrate that the declarant was fit to make the statement. Even with an examination of the doctor, the declaration can be acted upon provided the court ultimately holds the same to be voluntary and truthful. A certification by doctor is essentially a rule of caution. Therefore, the voluntary and truthful nature of declarant can be established otherwise. Then paragraph 4. Bearing in
Okay,
mind,
with this,
lordship,
2 minutes.
mild. Constitution. Lakshman. State of Maharashtra. So there is no possibility to doubt the veracity of the dying declaration made by the victim, my lord, before her death. In the instant case which I have referred, your lordship, para 4 and 5, where doctor has not been examined, but the magistrate, he gave the evidence that the declarant was in a fit state of mind. So
This
it,
is recorded by the doctor, not by the magistrate.
yes, but that two doctors, one casual officer of the GMC.
And there is no bar for a doctor to record the statement.
My lord, there is no bar. And why these official witnesses, they have no personal interest, my lord.
And
Why?
para 10, is there anything in the para 4?
Therefore, may I read it, your lordship?
Yes.
Bearing in mind the aforesaid principle, let us now examine the two decisions of the court which persuaded the bench to make the reference to the constitution bench. In Papadambaka, Rosamma and others versus state of Andhra Pradesh,
This one.
1997 SCC 695, the dying declaration in question had been recorded by judicial magistrate. And the magistrate has made a note that on the basis of the answers elicited from the declarant to the question put, he was satisfied that the deceased was in a fit disposing state of mind to make a declarant. Doctor had appended a certificate to the effect that the patient was conscious when recording the statement. Yet the court came to the conclusion that it not be safe to accept the dying declaration as true and genuine and was made when the injured was in a fit state of mind, since the certificate of the doctor was only to the effect that the patient is conscious while recording the statement. Apart from the aforesaid conclusion in law, the court also had considerable lacunae and ultimately did not accept the dying declaration recorded by the magistrate. In the later decision of this court in Kohli Chunilal Sabzi versus another versus state of Gujarat, 1999 9 562, it was held that the ultimate test is whether the dying declaration can be held to be a truthful one and voluntarily given. It is further held that before recording the declaration, the officer concerned must find that the declarant was in a fit condition to make the statement in question. The court relied upon the earlier decision in Ravi Chandra versus State of Punjab, 1998 9 SC 303, wherein it had been observed that for not examining by the doctor by dying declaration recorded by the executive magistrate, the dying declaration orally made need not be doubted. The magistrate being disinterested and there being no circumstances or material to suspect that the magistrate had any animus against the accused or was in any way interested for fabricating a dying declaration, question of doubt on the declaration recorded by the magistrate does not arise. The court also in the aforesaid case relied upon a decision of this court in Harjeet Kaur versus State of Punjab, 1999 6 SCC 545 case, wherein the magistrate in his evidence has stated that he had ascertained from the doctor whether she was in a fit condition to make a statement and obtain an endorsement to that effect. And merely because an endorsement was made not on the declaration but on the application would not render the dying declaration suspicious in any manner. For the reasons already indicated earlier, we have no hesitation in coming to the conclusion that the observations of this court in Papadamba, Rosamma and others and so to the effect that in the absence of medical certification that the injured was in a fit state of mind at the time of making a declaration, it would be very much risky to accept the subjective satisfaction of a magistrate who opined that the injured was in a state of mind at the time of making the declaration has been too broadly stated and is not the correct enunciation of law. It is indeed a hyper-technical view that the certification of the doctor was to the effect that the patient is conscious and there is no certification that the patient was in a fit state of mind, specifically when the magistrate categorically stated in his evidence, indicating the questions he had put to patient and from the answers elicited, was satisfied that the patient was in a fit state of mind, whereafter he recorded a dying declaration. Therefore, the judgment of this court in so and so must be held to be not correctly decided, and we affirm the law laid down by Kohli Chunilal Sabji. So his citation
The citation goes for a
Overruled.
6.
is. So nothing remains, your lordship, the prosecution could prove beyond reasonable doubt against the case. The direct declaration made by the declarant is enough to convict the accused. So my respectful submission is that your lordship will be pleased to convict, appeal the conviction.
Okay. One question,
My lord,
how did how did the deceased catch fire? Where did she catch fire?
yes,
In the kitchen.
Huh?
In the kitchen,
In the kitchen.
in the,
Who was in the kitchen? How did
my explanation in 313, I was in the bathroom.
he
I
was in
heard
the
the scream.
bathroom?
I came and saw her in a breeze.
So you were
Try
in
to
the
save
house
her.
together, both of you.
I was in the house.
Both of you in the house together. When did you marry, by the way?
In the same year,
Huh?
in the same year,
In the same year?
in the same year she died,
Oh,
in the month of February.
February
12,
2012, you married.
March.
And when did she
She
die?
was carrying
16/11/2012.
16/11/2012, she died. And incident occurred on 15/11.
15/11 night, around
15/11 night. She was how many months pregnant?
9. As
9 months pregnant.
nothing has been stated what happened to the baby.
So naturally, my lord, a caring mother will not lordship
9 months pregnant.
cause harm to her, my lord.
That means she was just about to give birth.
Yes, my lord.
And so baby died also. Actually,
Nothing has
unborn
been-
baby died.
Nothing has been.
And your lordship will kindly have a look at it, page 88, the sketch map,
88.
my lord of the paper book. Page 89, your lordship will kindly have a look, place of occurrence, A indicates which is the room of deposit corridor which is rented out by the
Where?
Dakoti. Page 89,
Yes.
A is PO,
Indicates PO. Yes.
PO is A, B is kitchen, so where is the possibility, the occurrence have taken
It
place?
was in the room of deposit.
Yes.
Kalita. That is the
Yes,
occurrence.
room, and B is the kitchen, adjacent. Lordship,
No,
that
B
is the kitchen they use as a kitchen, my lord, that room.
He is vacant, man.
B indicates the adjoining room. Adjoining room.
Yes, yes,
Okay, where is the kitchen?
yes.
G indicates kitchen. It is situated to the north of the PO. Anyway, they were together in the house.
Yes,
You were having what, bath?
I was having.
Oh, so coincidental. And what type of kitchen utensil were you using? Gas or kerosene stove or what?
Nothing has been proved by the
Nothing,
prosecution.
nothing.
They say there was a stove. They
Stove.
seized the stove and
Caesar.
a 2-liter bottle.
2-liter bottle.
But whether there was kerosene or not, nothing has been stated by the prosecution.
You'll be doing best. Section 106.
That I have already stated. I was in the bathroom.
There's nothing, no evidence and
And
record
thereafter
to
the
prove
prosecution has
this.
to prove. The circumstances have to be proved by the prosecution, Margaret.
Anyway,
Whether it was me who had inflicted that fire or
but
It was
is
accidental.
it your case that there was somebody else in the house?
No. I say it's accident.
Okay. Did I see 313, which page?
313, my page 34.
Page 34, madam. Relevant is page 37,
Yes.
last question.
Last,
Second
last
last
part,
question.
yes.
Do you have anything to say, Swanshu? At the time of incident, I was in the bathroom and hearing the hue and cry, I came out and poured water on her body.
You were in the bathroom doing what? It does not say that you were having a bath.
And the sketch map does not show where the bathroom is, whether we were using common bathroom.
Cooking. or anything else.
Yes, what was she doing? You said that where have you said that she was in the kitchen?
Lordship, from the evidence of PW4,
Ah,
evidence of PW4.
PW4.
Page 16, I saw a gathering in the residence of the accused devotee. I also noticed his wife Bulu Kolita laying on a bed with burn injuries. I asked the accused as to how his wife sustained burn injuries. In reply, the accused told me that while she was preparing tea in the kitchen, her clothes somehow caught fire. After some time, one ambulance arrived.
But then nothing is stated in the evidence.
In 313, nothing. Demand of dowry is there, your lordship, then. 302 will subsequently.
Witness was declared hostile.
Yes,
PW4.
PW4.
Okay.
PW4. Yes, he has been declared. hostile.
But anyway, this portion can be considered.
If it's supported by any other independent.
Yeah, no, I mean,
On that, I'd
yes,
like to rely on another decision, my lord.
just a minute. Yes, what is
Two
it?
thousand nineteen, volume 13, SCC,
2019, volume 13, SCC,
page 289,
289, yes,
paragraph 9, 19 to 22.
19 to 22, yes.
Paragraph 9. The
Yes.
essentials of circumstantial evidence stand well established by the precedents, and we do not consider it necessary to reiterate the same and burden the order unnecessarily. Suffice is to observe that in a case of circumstantial evidence, the prosecution is required to establish the continuity of the links of the chain of circumstances so as to lead to the only and inescapable conclusion of the accused being the assailant, inconsistent or incompatible with the possibility of any other hypothesis compatible with the innocence of the accused. Mere invocation of the last seen theory sends the facts and evidence in a case will not suffice to shift the onus upon the accused under section 106 of the Evidence Act. Unless the prosecution first establishes a prima facie case, if the links in the chain of circumstances itself are not complete, the prosecution is unable to establish the prima facie case, leaving open the possibility of that occurrence may have taken place in some other manner. The onus will not shift on to the accused, and the benefit of doubt will have to be given. Paragraph 19, madam.
Yeah.
Section 313 CRPC cannot be seen simply as a part of audio altering pattern. It confers a valuable right upon the accused to establish his innocence and can well be considered beyond a statutory right as a constitutional right to a fair trial under section Article 21 of the Constitution. Even if it is not to be considered as a piece of substantive evidence, not being on oath under section 3132 CRPC. The importance of this right has been considered time and again by this court, but it yet remains to be applied in practice, as we shall see presently in the discussion to follow. If the accused takes a defense after the prosecution evidence is closed under 3131B CRPC, the court is duty bound under section 3134 CRPC to consider the same. The mere use of the word may cannot be held to confer a discretionary power on the court to consider or not to consider such defense, since it constitutes a valuable right of an accused or access to justice. The likelihood of the prejudice that may be caused thereby, whether the defense is acceptable or not, and whether it is compatible or incompatible with the evidence available, it is an entirely different matter. If there has been no consideration at all of the defense taken under section 313 CRPC, in the given case, given facts of case, the conviction may well stand vitiated. To our mind, a solemn duty is cast on the court in dispensation of justice to adequately consider the defense of the accused taken under section 313 CRPC and to either accept or reject the same for reasons specified in right. 20. Unfortunately, neither the trial court nor the high court considered it necessary to take notice of, much less discuss or observe, with regard to the aforesaid defense by the appellant under section 313 CRPC to either accept or reject it. The defense taken cannot be said to be irrelevant, illogical, or fanciful in the entirety of the facts, and the nature of other evidence available as discussed herein before. The complete non-consideration thereof has clearly caused prejudice to the appellant. Unlike the prosecution, the accused is not required to establish the defense beyond all reasonable doubt. The accused has only to raise doubts on a preponderance of probability as observed in so and so case. Reported in so, which states, we have examined the evidence at length in this case, not because it is our desire to depart from the usual practice of declining to reassess the evidence in an appeal here, but because there
I
has
think
been
I've heard you. What, that's not right. All right, Mr.
B. Prasad.
B.
Prasad.
Prasad, learned counsel for the appellant. There was only one accused.
Only one.
Yes,
B. Prasad,
the
learned
appellant, there
counsel
were
for the appellant, as well as Ms. B. Boyan, additional PP. This appeal has been preferred against the impugned judgment dated 17/9/2014, passed by the learned session judge Kamrup M. Guwahati in sessions case number 38/2013, by which the appellant has been convicted under section 302 IPC and sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 5,000 in default, simple imprisonment for 6 months. On account of having intentionally caused the death of his wife by burning her with kerosene. Next slide. The prosecution case in brief is that an FIR dated 16/11/2012 was submitted at the Maligaon Police Outpost by the informant PW number PW-2, who stated that that her deceased sister married the appellant and started living with the appellant and her mother in thereafter. The deceased suffered mental and physical torture due to dowry related demands, and for which large amounts of money had been paid to the appellant and to the appellant. However, the deceased was set ablaze on 15/11/2012 at 9 p.m. The appellant and her mother and the appellant and his mother thereafter made an attempt to show that the burning of the deceased was an attempt to commit suicide by the deceased. The deceased was admitted to the Guwahati Medical College Hospital by the appellant and and thereafter the informant was informed of the same. On arrival at the hospital, the informant was informed. On arrival at the hospital, the informant was informed. No, no, the arrival of at the hospital, they noticed the severe burns on the body of the deceased who was still alive and saw that she was in unbearable pain. Most of the deceased thereafter informed them in a broken voice that she had been set ablaze by the appellant and her mother-in-law after torturing. The deceased thereafter succumbed to her injuries at 7:40 a.m. on 16/11/2012. Acha, FIR is also 16/11, huh? Not 15/8, 16/11. Next para. In pursuance to the FIR submitted by the informant bracket PWT, comma, Jalukbari PS case number 808/12 under section 304 bracket B IPC was registered. After investigation was completed by the police and a charge sheet was submitted, comma, the appellant, the learned trial court framed a charge, framed the charge under section 304 bracket B, capital B of the IPC against the appellant, to which the appellant pleaded not guilty and claimed to be tried. Full stop. Next para. During the trial proceedings, comma, 11 prosecution witnesses were examined. Full stop. Thereafter, the appellant was examined under section 313 CRPC. The learned trial court thereafter came to a finding that, before that, you're right, before, you say, during the trial proceeding, before 313, during the trial proceedings, comma, an additional charge under section 302 IPC was framed against the appellant on what was the date? 18/3/2013. Then what have I said? Stop. Full stop. Full stop. Came to a finding that the death of the victim could not be called a dowry death. Full stop. However, on the basis of the evidence adduced by the prosecution witnesses, it came to a finding that the appellant had set the victim ablaze. Due to which, which caused her death. Full stop. As such, the appellant was found guilty of the offense of murder under section 300 IPC and was accordingly convicted under section 302 IPC for committing murder of his wife. Full stop. He was accordingly sentenced to undergo rigorous imprisonment for life. No, imprisonment for life. That's it. Undergo imprisonment. Imprisonment for life with a fine of rupees 5,000, in default. Simple imprisonment for 6 months. Next part. The learned counsel for the appellant has made a challenge to the impugned judgment dated 17/9/2014 passed by the learned trial court on 5 grounds. Firstly, the original dying declaration recorded by the doctors was not produced in court, was not produced before the trial court. First up. No, was not produced before the trial court, in as much as PW1 and PW9 had stated in their evidence that the dying declaration, that the recorded dying declaration, which was exhibited as EXT-1 was the carbon copy. Full stop. Secondly, the doctors had not given any certificate or certification to the effect that the victim was in a fit mental condition to give a dying declaration. Full stop. Thirdly, though charge was framed under section 304B IPC, the appellant had been convicted under section 302 IPC without any charge being framed under section 302 IPC. Fourthly, the demand for dowry had not been proved by the prosecutor. And fifthly, the circumstantial evidence did not form a complete chain to prove the guilt of the appellant in the death of his wife. With regard to his submission that dying declaration can only be accepted if there is a certification to the effect that the victim was in a fit mental condition to give a dying declaration. The learned counsel has relied upon the judgment of the apex court in the case of Papa Rambaka, Rosama and others versus State of AP, reported in 1999, 7 SCC 69. And in the judgment, in the division bench judgment of this court, in the case of Sunil Kanti versus State of Assam, reported in 2022, 4 GLP 45. Yes, sir. In respect of his submission that the that the circumstantial evidence could not establish the guilt of the appellant as the same did not form a complete chain of circumstances. Here relied upon. The learned counsel for the appellant has relied upon the judgment of the apex court. Say Supreme Court, or wherever I said apex court is Supreme. And Supreme Court in Reena Hazarika was State of Assam reported in 2019, 13 and 52. The learned counsel for the appellant thus praised for setting aside the impugned judgment and order passed by the learned. The learned counsel, the learned Mrs. Buyan, learned additional PP for the State of Assam. Our submits that the signatures of the doctors who had recorded, who had recorded the dying declaration and who had witnessed the same were all original signatures.
The one who had recorded, his signature is not in original. The witnesses are in original.
Which page is it?
Of the record, you also will see the record,
Where is, which page is the dying declaration?
page 55. Page 55, madam.
Nishan Bish,
Nishan
he's
is,
the one who recorded it.
it's in carbon copy. It's in carbon copy.
It's a carbon.
The witnesses are original.
Put in a signature with its authority. This is the carbon copy. but
Yes.
Signatures are already.
That's what I'm saying. That's
Dr. Bist, who had
No, no,
recorded, his signature is not in original. It's same, in the same carbon copy.
Witness.
The one who reported it.
PW9 in his statement himself has said that that is my carbon copy signature. Exhibit
So how does it prejudice?
If your lordship is recording, it should be recorded correctly that.
No, okay, okay. No, anyway, that doesn't, okay. Correct. So what if I said? Submit, how to submit that? Though the dying declaration that has been submitted before the learned trial court was a carbon copy. The signature of the witnesses to the dying declaration were original. She also submits that there is no dispute with regard to the victim having made the dying declaration.
The other two witnesses also supported. PW
Sure.
1 and 3.
She also submits that there is no requirement of any certificate or certification being made by the doctors stating that the victim was in a fit state of mind to make a dying declaration. As they had categorically stated. No, as their statements that the victim was fully conscious implied that the victim was in a fit state of mind to make the dying declaration. She also submits that the law laid down by the apex court in Papa Rambaka, Rosama and others, Supra, which has been relied upon by the counsel for the appellant, has been held to be not
correct.
has been held to be not laying down the correct enunciation of law as per the decision of the Constitution Bench of the Supreme Court in the case of Lakshman versus State of Maharashtra, reported in 2002, 6-710. That's all. Any-
The authenticity of the dying declaration depends on lordship because it's before whom it was made. Subjective satisfaction of the
So she
person
submits
before whom
that
the
the
dying declarations.
the evidence of the doctors who had recorded the dying declaration and who had witnessed the dying declaration would show that the person, that the doctor who had recorded the dying declaration, no, would show that uh, uh, there was subjective satisfaction of the doctor who recorded the dying declaration, that is PW number.
PW number 9
PW-9.
and PW 1 and 3 also supported
1 and 3 are witnesses.
witnesses to the dying declaration. Further, they have no personal enmity or interest into the matter, my lord. They being the
Three,
official-
three, three.
Yes, schedule officer, my lord. Witness to the dying declaration.
Okay, three. Yes. The learned additional PP also submit that the circumstantial evidence clearly proved the involvement of the appellant in the death of her in the death of his wife, in as much as they were the only two persons in the house at the time. The 9 month pregnant wife was set ablaze by pouring kerosene by way of using kerosene in the house, occupied by both
Lordship,
of them.
in the case, other person, mother-in-law was also there.
No, mother-in-law is not.
No, as per the.
As per the
FIR,
FIR, PW2 says mother-in-law was also there. The
she was acquitted subsequently, over.
No, it's not been.
charge sheet was not submitted
Okay,
against her.
okay.
No evidence was found.
So
So
she's
that-
not there.
That point that only two persons may go,
Only 2%, the victim and the
because a mother-in-law was also there.
Mother-in-law also there. Okay, what about that? In as much as they were, they, in as much as, in as much as the appellant has not made any explanation as to how the deceased could have caught fire. Correct,
Yes, and he himself was present in the residence.
while being present in the residence
Yes. that he
at the
did
time of the
deny.
incident. That's all? Anything else?
Right.
I think that's all. We have heard the learned counsels for the party. A perusal of the records shows that the dying declaration had been recorded by Dr. Had been recorded by the doctor. Bracket PW9. Who had given treatment to the deceased when she was brought into the hospital. The dying declaration was recorded by PW9 in the presence of three other doctors. That is Dr. Dibya Jyoti Bora, Dr. Bishmoy Das, and Dr. Asman Ali. Acha, you just say in the presence of Dr. Dibya Jyoti Bora, bracket PW1, then Dr. Bishmoy Das,
not
PW,
recorded.
Huh?
Not recorded.
not recorded,
Asman Ali is PW3.
not there, and Dr. Asman Ali,
PW3.
PW3. Huh. Dr. Bishmoy Das has however not been made a prosecution witness in the case. The above being said, PW1 has stated in his evidence that he was present when PW9 recorded the dying declaration of the deceased. He also states that at the time of making her dying declaration, the deceased was fully conscious and she clearly stated that she had given her statement without any external pressure or influence. So stop. She also stated that her husband poured kerosene on her body and thereafter set her on fire by lighting a matchstick around 9:30 p.m. of 15/11/2012 in her residence at Maligaon. He also states that Exhibit 1 is the carbon copy of the said dying declaration prepared by PW9, wherein Exhibit 1 bracket 1 was his actual signature as a witness. In his cross-examination, PW1 states that the medical officer of surgery department, Dr. Asman Ali, PW3, was present at the time of recording of the dying declaration, along with Dr. Biswamoy Das. Biswamoy Das. Full stop. He also states that no relative of the deceased was present at the time of recording of the dying declaration. He again states in his in his cross-examination, PW1 further states that the deceased was fully conscious and her speech was also quite normal. Next paragraph. The evidence of PW3, that is PW3 is that he was on duty as a casual officer on 15/11/2012 at the Guwahati Medical College and Hospital. On the said date, the deceased was brought to the hospital at around 9:30 p.m. with more than 90%, 95% burn. Further, the patient was 9 months pregnant. Full stop. As the condition of the patient was very serious, doctors working under him recorded the statement of the deceased, of the patient. Full stop. His junior colleague, PW9, recorded the dying declaration of the deceased in his presence. He also exhibited his signature. He also identified and exhibited his signature in the dying declaration as EXT 1 bracket 2. He also, in his cross-examination, he states that at the time of recording the dying declaration of the deceased, PW1, PW9, and Dr. Biswamoy Das were also present. He also states that the deceased gave a statement in the Assamese language, and the same was recorded by PW9 in the English language. He also states in his cross-examination that the deceased, he also denies the suggestion given to him that the deceased was not in a fit condition to give a statement because of her severe burn injuries. Next, PW9 in his evidence states that he was on duty on 15/11/2012 when the deceased was brought to the casualty department with more than 90% burn injury. Pusta. After giving initial treatment to the deceased and when her health condition became a little bit stable, it was decided to record her dying declaration. Considering the serious condition of the patient, accordingly, the dying declaration of the deceased was recorded by PW9 in the presence of PW1, PW3, and Dr. Bishwa Moidas. PW9 also identified the carbon copy of the dying declaration as Exhibit 1 and Exhibit 1(3) as his carbon copy signature. He also submits that, PW9 also stated that the patient succumbed to her injuries on the next morning. He also states that next. No, subpara. In his cross-examination, PW9 states that there is no endorsement in EXT1. No, there is no endorsement in the dying declaration that the contents of the same was read over to the maker. Or that there was any certification mentioned, that there's any certification made that the deceased was in a fit condition to give her dying declaration. However, in the report, it had been clearly mentioned at that time that she was fully conscious to give her statement. The questions put to the patient were in Assamese language and her answers were thereafter recorded by him in the English language as given in EXT-1. Next para. I think you talk to the pen. I'll do the rest. And then you just say, heard to the hearing concluded, judgment reserved. It'll take time at the way. I want the photocopy of this judgment. Yeah. Just print out one copy. It's too thick. Huh? Can you just 2 minutes? 2 minutes. 2 minutes. Huh? Yes.
My lord, I contacted her. She is not well. She has not come, but she has said that to fix it after, on 4th or 5th.
Has she got the paper book?
Yes. yes.
Okay,
She
that's
got
what,
the
that's
paper.
what we wanted. But then you said that in the morning she came.
I think I saw her. I think I saw her.
Ah.
But then I called her
Familiar face.
4th after 4th of August.
She said 1 or 2 weeks.
But she has received. Have you taken today?
I'm going to take.
Will you take it now? Okay, right. Mr. In the IA, huh? In the IA. Mr. D.K. Bhattacharya, a learned counsel for the applicant, submits that he has been engaged only to take up IA criminal 464/2023. He submits that Mrs. Dipanjali Bor Pujari is the amicus, is the legal aid counsel who will be taking up the case of the applicant appellant at the time of hearing of the main appeal. That is criminal appeal bracket J 34/2023. He also submits that paper book has been received by Mrs. Dipanjali Bor Pujari. Miss J. Paul, legal aid or what?
No.
Miss J. Paul, the learned counsel for the learned counsel for the appellant in the analogous appeal, that is criminal appeal 10 of 2023, submits that she will be taking a copy of the paper book from the registry during the course of the day. Full stop. Miss S. Jahan, additional PP, submits that she has received a copy of the paper book. Full stop. Next paragraph. This application relates to the impugned judgment dated 26/5/2022 and sentence order dated 30/05/2022 passed by the court of the special judge Morigaon in NDPS case number 3/2020, by which the appellants in both the above appeals have been convicted under section 22 bracket C,
And 29 of it.
read with section 29 NDLPS Act. So they have accordingly been sentenced to undergo
14 years.
RI for 14 years with a fine of rupees 1 lakh each, comma, in default to undergo SI for 3 months,
3 years.
3 years.
for 3 years. Pusta. Next paragraph. This application made under section 389 CRPC is for suspending the sentence and releasing the applicant L Sana Mete, L full stop, SANA Mete on bail on the ground that he is HIV positive. The, oh, don't write his name. Instead of SLM Mete, you just write, and the applicant in IA 464/2023, yeah. Bail, full stop. He has relied upon the advisory policy for treatment issued by the Ministry of Home Affairs, Government of India dated 13/8/2010 and the order dated 11/4/2022 passed by the Supreme Court of India in SLP number 2225/2022 bracket Bhavani Singh versus State of Rajasthan. For release on bail. Ms. S. Jahan, learned additional PP, on the other hand, submits that as paper book is ready, the matter can be heard expeditiously and the bail application may be rejected at this stage. Full stop. She further submits that in terms of the medical report dated 17/7/2023 issued by the Medical and Health Officer, District Jail, Morigaon, the applicant is suffering from AIDS/HIV infection, piles, skin disease with allergy, and what have I said? Full stop. Accordingly, he is given medicine, but he is not completely recovering. No, but given medicine, but has not completely recovered. Full stop.
Last line of that report is important.
It also says, it also states that there are no separate rooms for HIV patients of the jail. Full stop.
It is under construction, they said. 80% of the work is
Full
done.
stop. The additional PP submits that a separate room is under construction for HIV patient and 80% of the construction work has been completed as on date. Full stop. Next para. We have heard the learned causes for the parties. Full stop. The order passed by the Supreme Court in Bhavani Singh Supra is that is with regard to an HIV patient, an HIV prisoner. Wherein it has been stated that an HIV prisoner is entitled to be given the benefit under section 34(2) of the Human Immunodeficiency Virus and Acquired Immune Deficiency Syndrome (Prevention and Control) Act 2017 for expeditious disposal of his appeal. The Supreme Court had also accordingly directed the High Court to take appropriate steps to dispose of the appeal. And in the meantime, granted bail to the petitioner therein. Full stop. In the present case, next, keeping the above facts in view, we are of the view that instead of bail application, an expeditious disposal of the appeal should be made. Full stop. On the prayer of the counsels for the parties, list this matter for hearing on
After 10th August.
After
10th August.
here. No,
Can be taken up on 1st of August?
look, because you see one thing, you are in a hurry to have bail, but you're not in a hurry to have the appeal.
I'm ready.
Okay,
It can be done. It can be done earlier also.
no, you see, we have got no problem. But then we don't want you to go now. We'll clarify that. If you want 10th August, we'll give 10th August. But we'll clarify that we're ready to hear the matter today also, tomorrow also, but you want 10th August. Because we don't want you to go to Supreme Court and say that,
Third August.
look,
3rd August. Let it be 3rd.
okay, what have we said? 3rd August, full stop. It may be clarified here that though this court has informed the councils that we are ready to hear the matter today or tomorrow itself, they have the councils for the applicant appellants have prayed for a date not earlier than 3rd August 2023. Full stop. Accordingly, in that view of the matter, list this matter for final hearing on 3rd August 2023. In the meantime, we do not find, we are of the view that bail should not be granted, as the matter is going to be heard expeditiously at a date fixed by the council for the applicant appellants. Applicant appellant. The I is accordingly dismissed.
All right. Okay.
Yeah, big lordship. I am praying for some accommodation in this matter as preparing item number one.
No,
Tomorrow
huh?
On Friday, morning. I couldn't prepare this.
What to do? I don't know.
Tomorrow or Friday, I think.
Tomorrow, Lordship, I will not be there.
Thursday, I have a matter, Friday, matter. Okay.
Wait, where is today's list? I put it in that thing. Where is my? All this? Is it in that partnered matter, in that CAV matter? Or is it here? Ah, or is it here in this file? Yes, look. What to do then?
On Friday.
On the prayer for adjournment made on behalf of the Appellant's Council. This is the matter of Friday. Friday.
Mr. NJ Das, I saw him in the morning, perhaps he'll come.
What is this matter?
This is, there are eyewitnesses, 302.
Let us see the FIR.
Gotcha. Yes, I remember the facts here. What had happened is that the accused, he met with an accident with the son of the deceased. Because of him, the accident took place.
Because
And
of
the-
whom? Okay.
Because of the accused. And the son died. And because of which the deceased, the mother of the dead son, she used to rebuke him off and on. And then one fine day when she was coming home from a neighbor's place, he struck her on her head with an axe. And
So-
it was
so-
seen by so many.
I thought the appellant struck her.
Ah,
And because the appellant and in accident, what accident? Bike accident?
yes, bike accident
He was
because
riding pillion.
no, that is not clear. In his statement, the accused had said that because of me, the son of the deceased expired because of a bike accident. Perhaps he hit him or something. Because of which there was a grudge. And then the mother was carrying that mother was coming, she again rebuked. And then this has come in the evidence of the accused. Because I was trying to find out what is the motive. Simply a woman coming from a neighbor's place and he had struck her. And then I got this is the motive. And then it was seen by so many. It was in the daytime, 9 a.m. or 11:15 a.m. And then it was seen by the neighbors. There are, in fact, 4 eyewitnesses in the case. Person died also due to head injury. The mother. NJ, that's not.
Anyway, let us see the page 4 is the
Not sure. NJ, that's not here. He is very. Very short FIR, Lordship. It's
Ah.
very short FIR. Ejahar is a very small one.
struck my sister-in-law, Barwa.
And she is the he is the nephew. I mean the.
Huh?
The accused is the brother-in-law of perhaps they are relatives. Accused is the nephew of the deceased husband,
Or
brother's
deceased
son.
husband.
Brother's son.
deceased husband.
Deceased husband's nephew is the accused.
So husband's brother, elder brother, or younger brother.
Perhaps elder brother. Because PW4 is the husband of the deceased. He said, yeah, Noren Bora is my younger brother, accused Ashim is my nephew. Younger brother, but
Anyway, okay, it's the nephew
they are,
of the
yes, they're relatives.
husband of the deceased.
Noren Borua is the informant. Informant is PW1.
So, this, who is this? Informant is the,
Brother of the
so is it the
husband of
father? You
deceased.
don't know.
No, he is the
Another
brother
brother.
of the deceased husband.
Brother of the husband of the deceased.
PW4 and 1 are brothers.
Ah.
PW4's wife expired. Is the deceased here.
So PW1 is the informant.
Informant.
So that means the accused
Hmm.
is also the brother of the, is also the
Nephew.
nephew of PW1 also.
One also, yes.
Eyewitness,
Eyewitnesses are 2, 3, 8 and
PW2,
16.
PW3,
PW8
8,
and 16. Mr. Envidas is not here in his absence, Lordship. He keeps going to the lower court, that I know, but today he was there in the morning.
we'll appoint some Mike, and we cannot keep on waiting there.
Next letter, other side conflict also there.
This is item,
This is 6.
item 6. Okay. All right. No one appears for the appellant on call. This is the matter on Thursday or tomorrow.
Tomorrow.
Tomorrow, this is the matter tomorrow.
May I take the call?
Yeah,
Marat, this is the conviction was given under section 498A and 302 IPC.
498A and 302 IPC.
302 IPC. An imprisonment for life along with fine of 5,000 in default.
Yes,
The mother of the victim has lodged an FIR on 4th of April 2010.
4 April 2010.
Before the Bongaigaon PS,
Informant is PW.
informant is PW4. The mother of the victim.
The Lordship will find the FIR at page
It is actually 3. Where do you say 4?
3 is the eyewitness, that is the son.
It's the son.
FIR dated 3/4.
Yes, but it was registered on 4/4. Lordship will see page 1.
Okay.
There are some discrepancies in the dates. I will show that regarding the date of incident and this date of lodging of FIR. There are some discrepancies in the dates.
What is the relationship between the informant and the
Informant
deceased?
informant is the mother of the deceased. And the mother-in-law of the accused person. May I read the FIR first, method?
Just a minute. Yes,
Yes, but she says that yesterday, that is on 2/4/2010, the accused person demanded rupees 10,000 in cash from my daughter and then came to know about it over phone. As my daughter refused to bring the money around 2 p.m., the accused person poured kerosene on her body and set her on fire with the intention of killing her. As a result, my daughter has been undergoing treatment at Dankal Railway Hospital, and I am thinking of taking her to a nursing home in Cooch Behar for better treatment. I therefore pray to you to take necessary action upon investigating into the matter and oblige. So this FIR was filed on 3/4/2010, and from the statement of the investigation officer, it reveals that this FIR was filed at around 10:30 p.m. at night.
I don't know. Let us see.
Yeah. It's also reflected in the judgment also. My lord, page 21, the first IO.
It was registered on 4/4/2010.
On 4/4.
Yeah.
This FIR was launched on 3rd of April at 10:30 p.m.
Where do you get the 10:30 p.m.?
Page 21, the IO also says. Page 21.
Yes.
On 3/4/2010, I was working as IC North Bongaigaon PP. On that day at about 10:30 p.m., one Srimati Namita Roy, the wife of so-and-so, lodged and written FIR at North Bongaigaon PP stating that her daughter Pratima Burman was married to Kalyan Burman, so-and-so, so-and-so. So the FIR which I have referred, it was lodged on 3rd of April 2010 at 10:30 p.m.
Yes.
Now, except this, the 9-year-old son, there is no eyewitness regarding the incident. Now, the mother also in the FIR itself on 3rd of April does not say that the at 10:30 p.m. she does not say about death of her daughter. She only says that she is undergoing treatment at railway hospital and she is thinking to take her to the.
So when did she die?
That is the thing. And from the inquest report, I find that the time of death is 7 p.m. There is some contradictory in this aspect.
Page?
Page 68. The inquest report. She died in Cooch Behar. On way when the informant was taking her from Bongaigaon to Cooch Behar for her treatment, she died on way.
The inquest report dated?
Inquest report. the type copy and the date has not been mentioned. Here. Date
No,
is-
what is wrong? He died at 7 p.m. and files the FIR at 10:30 p.m. What is wrong?
My lord, the thing is that on 3rd of April 2010, if her daughter has died at 7 p.m.,
Ah.
she lodges an affair
At 10:30
at
p.m.
10:30 p.m. There's no harm in it, but she does not say that her daughter has died. The FIR doesn't speak about death of her
Okay. Talks about undergoing.
undergoing treatment, and she intends to take her to Coach Behar for treatment. That's enough.
Might not have known that her daughter had died.
So she came only for her daughter from Coach Behar to Bongaigaon for her treatment when she heard about this incident. And she was all along with her daughter. She intended to take her to Coach Behar. And when the daughter died at 7:5 p.m. at Coach Behar, not in Bongaigaon, she died in Coach Behar,
Where do you read that?
page 68. Is the
In
inquest
Coach
report,
Behar.
inquest report by reference under Kotwali PS UG case number
And FIR is lodged at Bongaigaon.
Bongaigaon. She died at 7 p.m. at Coach Behar, and the FIR is lodged in Bongaigaon at 10:30 p.m. Now, may I take your lordship to the depositions? There is some discrepancy regarding the dates. Even the son, who is the eyewitness, he also says that the incident took place on 1st of April 2010. The other witnesses also says that the incident was occurred on 1st of April 2010.
Okay, son is PW.
Son is PW
Three.
3.
And who are the other witnesses who said that it occurred at 1?
Yes, PW2 is a neighbor.
Incident occurred or died?
Incident occurred. From this paper,
Occurred on 1/4.
1/4. But the informant says the incident occurred at 2nd of April. So she files an FIR on 3rd of April at 10:30 p.m. at Bongaigaon. The police investigation officer confirms it that on 3rd of April at 10:30, the FIR, written FIR was lost. But the inquest report says that she died on 3rd of April at 7 p.m. at Coach Behar.
7:30.
7:05 p.m. Moreover, the investigation, there were 2 investigation officers. They have not collected any seized, they have not seized any materials from the place of occurrence. They have not
How
collected.
did she die? How
The
did the
postmortem report says it might be from the shock of this burn.
shock of the bird?
Yes.
She was burned.
She was burned, partially burned, but she was taken from the Dibrugarh Railway Hospital by her mother, the informant, to Coach Behar. And according to her, on the way, she has died. And the postmortem report was also not been called for. And the
So no postmortem report.
This
That-
is the PM report.
PM report.
T is
Then what?
PM report original has not been called for because there was in Coach Bihar, there was another case was registered. It's reflected in the judgment. I think true. And the cause of death, in the opinion of the medical officer, was due to shock from the above stated burn injury, which was anti-mortem in nature. No percentage of burn was mentioned in the reports, medical report. Of the percentage of burn, that was also not mentioned. And the investigation and the investigating officers, they did not even uh, uh, examine the medical doctors of the Dangkal Railway Hospital where she was first admitted for treatment. May I take your lordship to the PW7, who is the medical officer. Page 23. On 4/4/2010, I was posted as medical and health officer at MJN Hospital, Coach Bihar. On that day, I conducted postmortem examination on the dead body of Pratima Verman, 29, female, New Bongaigaon, railway quarter, on being identified by Constable 1 so and so in connection with Kotowali PS UD case number 14210 dated 4/4/2010 and found as follows. External appearance and average build female body. There was superficial burn injuries of the whole body excepting the face and foot. Then the opinion, next page, the opinion was given. In my opinion, the cause of death was due to shock from the above stated burn injuries, which was antemortem in nature. Exhibit 5 is the postmortem report, wherein Exhibit 5(1) is my signature. During cross-examination, he admits that in the report, I have not mentioned the percentage of burn injuries. Without advice and consent of the doctor, if a patient party takes away the patient from the hospital, responsibility lies on the patient party. As per record, the disease was admitted in MZN Hospital, Coach Bihar. In my report, I have not mentioned the time since death as well as age of the burn injuries.
He is a doctor from,
Coach Bihar.
and he said that patient party takes away the patient. Who took away the patient?
They took the informant, the mother of the
Took away the patient.
took away the patient from Bongaigaon.
No, but this is from Bangladesh.
The medical officer of the Bongaigaon hospital were not examined.
But then he said that I reside at NNN Road, Coach Bihar.
Yes,
Then out here he says Bongaigaon in page 24.
no, he says that if he says that he's a doctor since the doctors from the Bongaigaon hospital, railway hospital, were not examined. So the question was put to him.
Where is Coach Bihar, by the way?
Coach Bihar is West Bengal, in West
West
Bengal.
Bengal. No,
Yes.
so what I'm saying is, you come to page 23.
Yes,
He says that I reside at RRN Road, Coach Bihar Police Station,
Yes.
Coach Bihar.
Yes.
And he says on 4/4 I was posted as medical health officer at Coach Bihar.
yes,
But come to page 24.
Yes.
The seal is of Bongaigaon.
It's session judge's seal.
Registration
Session
is there.
judge.
Oh, okay, okay, okay. I
Session judge.
thought it was.
No, it's not very legible, although. In the previous page also.
So patient takes away the patient from the hospital. But taken away by whom we do not know. And take away alive or dead?
That is
Dead,
also
dead.
not sure.
No, dead, basically dead.
Because
Actually, otherwise,
That's why,
opinion,
that's why, Lordship, I have indicated that on 3rd of April 2010, when the informant lodged the FIR at 10:30 PM, according to the informant, she intended to take her daughter to Coach Bihar on 3rd of April, 10:30 PM in the FIR, as per FIR.
GD entry is recorded.
And moreover, the son, who is the sole eyewitness to the incident, he says the incident took place on 1st of April 2010. And the other witness also says the incident occurred on 1st of April 2010.
that's the basic case.
Well, that apart, the Lanet trial court has relied upon the FIR itself, which was admittedly, but in the judgment, it says the FIR was lodged on 3rd of April at 10 AM.
Yeah,
AM. Whereas the IO says it's 10:30 PM. And the London trial court has held that FIR was lodged on 3/4/10 at 10 AM. So there are discrepancy between the dates, times, and the plea taken by the accused was that he was not there at that time when the incident occurred.
yes, madam.
Lordship, the moot question is that the case of the prosecution, the evidence of PW3, eyewitness to the occurrence, he saw the occurrence, and evidence of PW2, that the accused person very much present, he locked the door at the time of commission of the crime, my lord. So
Only
if
PW3
it is believable, the evidence of PW2 entry, and all those infirmities, inconsistencies, for sure, I think it may be overlooked, my lord. PW3 is the.
Anyway, we'll take it up at
eyewitness.
2. Let us see what she has said in the Jahar, page 4. Now this has been submitted at what time? No, 10:30. When did the victim die? No, no, according to you, when did, okay. That is why, that's why I'm asking you. Yes, that is why, it's a inquest report says 7. Now, that is why I want to know if there is any document to show any other time of death.
Documents now. When the. Subsequent to
This, I think this will need to, we'll have to go through the records a little bit. Which date? If she died on 2/4,
It's before why it is not mentioned in the file.
why did she not mention it in the FIR on 3/4? And then why in the FIR has the mother said on
3/4 she
3/4
was taking her
at
to
10:30 that she was going to take? I am thinking of taking her, not even taking her as yet. I am thinking of taking her to a nursing home. No, but then she had already died. Prior to that, when she had already died on 2nd, why will she on the next day write a FIR saying that I am thinking of taking my daughter to Kuch Bihar when she has already died, as if she didn't know about the death?
And Downtown Railway Hospitals, doctors, they are not,
Yes, she was first taken to Bongaigaon Hospital, Railway Hospital.
railway hospital.
Where is the doctor?
doctor.
Who did they go to? No evidence. Why didn't the police investigate that? Very dead. Now. And according to PW3, the deceased died on first. I was injured on first, not on second. The incident took place on 1/4/2010. What about the elder brother? He was the younger son.
Nothing on record. It reveals from the records that he was in Kuch Bihar.
The elder
And
son.
that's it.
One, two, three, three,
I don't.
three, four, seven, five.
Who died?
Three,
Fatima died on 3/4. That is the impressive.
three, four, seven, five.
3/4. So outside says 3/4, not 2/4. And do what? I don't.
Date is different.
Let her see, because there are some discrepancies. It's not minor, you see. I mean,
Copy of. Fire
what do you want? A copy of what? The entire thing or what?
is dead.
Oh, How many pages is it? Who will do the photocopying? We'll do the photocopying. Can you do the photocopying of the? Huh?
Case diary.
They can do. Okay,
Okay, take the.
okay, all right. Heard Mr.
Edhar,
Adar Leonard Council for the appellant. Council or amicus?
amicus.
Then amicus here. And Ms. B. Boyan, additional people. On a on hearing the counsel for the party, there appears to be discrepancies not only with regard to the dates, but also the time of death of the deceased. The deposition of the witnesses, prosecution witnesses also do not appear to be in sync. SYNC, huh? In then separately sync with each other. Next para, Ms. B. Boyan, additional PP. Prays for a copy of the a photocopy of the CD. This you can get, I think, the CD and the exhibit. So that she can argue the matter on another day. Praise aloud. Registry to furnish photocopy of the exhibits and the CD to Ms. B. Boyan, additional PP. Personal. When do you want? This the matter after a week. Hundred part, yeah. This leaves the matter. When? When? No, Monday, Tuesday, I think is booked. Wednesday. Okay, when the 26th, that's partner.
Nice.
Item number 8 and 9.
Well, good for the appellants then.
There are two appeals, my lord. I am appearing in item number 9. My learned friend appears in item number 8. I appear for the husband of the deceased and she is appearing for the father-in-law. It means the father and the son.
And item 8 is
He is the father-in-law, father-in-law of the deceased and father of the petitioner in item number 9.
appellant.
Appellant.
Yes,
So against the judgment dated 8/1/2020, my lord, where both of the petitioners, my lord, have been found guilty on the under 302 and 201, my lord. Murder and destruction of evidence. Take your lordships to the FIR, my lord.
yes,
Page 4, my lord.
yes. FIR dated,
FIR dated 21st of February 2017. ma'am.
yes,
Humble submission is that today, that is 21/2017, Shri Birendra Chauhan, son of Zakari Chauhan, a resident of village so and so, killed his wife Suman Devi, who was my niece, by assaulting her and burnt the dead body. I therefore pray to you to investigate the matter and so and so.
who is this informant?
Informant is the uncle, my lord.
Uncle of deceased.
uncle of the deceased. He is the PW1, my lord.
Yes, then
The PW1 lordship will find at page 8 and 9, my lord.
8 and 9. Yes,
I am the informant of this case. I know the accused Virendra Chauhan and Zakari, it should have been Zakari, my lord. Deceased Suman Devi was daughter of my brother. The occurrence took place about 1 year back. One day morning at about 10 a.m., one person from the village of the accused over telephone informed me that the deceased died. My house is situated at Bogori Ghat, which is about 60 kilometers away from the house of the accused. Immediate after getting the information over telephone, I proceeded towards the PO and reached the house of the accused at about 1:30 p.m. Coming to the house of the accused person, I found none there. During search, one woman residing near the house of the accused person informed me that the accused Virendra, who was the husband of the deceased, killed her. Thereafter, I tried to meet
this
the
one woman, was she made a witness? Who is this one?
She is not named, my lord. She is not
We
named,
don't know who.
not made a witness. In fact, his evidence is also hearsay, my lord. He simply says that he has come there after the incident. Thereafter, I tried to meet the neighboring people to make inquiry. Further, I found none in their house. Then I straight went to the so-and-so police station and lodged the written FIR. Exhibit 1 is my Ejahar and Exhibit 1 is my signature. Aforesaid woman also informed me that in the morning of the occurrence about 7 a.m., she found the members of the house of the accused person and deceased moving in the vicinity of their house, and thereafter she heard shouting in their house. The aforesaid also informed me that immediate after shouting taken place at 7 a.m., the dead body of the deceased was cremated. Police visited the PO as well as the place where dead body was cremated. The cross-examination part, after about 1 year back from the date of occurrence, marriage between the deceased and accused Virendra was taken place. I did not hear that there was a quarrel between the accused Virendra and the deceased. I did not make any inquiry to ascertain who over telephone informed me about the death of the deceased. I do not know the name of the woman as stated above. I also visited the place where deceased was cremated along with the police. We found none in the place where deceased was cremated. We found some woods burning. It is not a fact that the accused Virendra did not kill the deceased. It is not the fact that today I depose false. PW2, my lord, is a neighbor, my lord. I know the informant. I also know the accused person. 1 year prior to the occurrence, the deceased got married with accused so-and-so. So-and-so is father of the accused Virendra. The occurrence took place about 1 year back.
Neighbor. He's a neighbor.
He is a neighbor. The occurrence took place about 1 year back. On the day of the occurrence at about 7 a.m., while I was in my house, I heard shouting in the house of the accused persons. Due to my illness, I did not go to the house of the accused persons in spite of hearing shouting. At 7 a.m., I found the accused Zakari Chauhan near my house, and on being asked, he told me that the deceased committed suicide with a sari at about 7 a.m. in their house. My house is about 14 knolls away from the house of the accused. On that day at about 2 p.m., police came to my house, to the house of the accused persons. Police making round in the village entered into my house on that day at about so-and-so. I saw the villagers and the accused persons taking the dead body of the deceased in a plank for cremation towards sugarcane field. Seeing the coming of the police in the village, all villagers left their house, but I could not do so due to my illness. Police examined me. One thing is important, my lord. He says that the dead body was cremated in the presence of the villagers. But you will kindly make a note, my lord. I saw at 9 a.m. I saw the villagers and the accused persons taking the dead body of the deceased in a plank for cremation. The cross is very small, my lord. I never heard any quarrel taken place between the deceased and the accused. About 10-12 persons of the village took part in the cremation of the deceased.
Why did all the villagers leave their house on seeing the police?
In village areas, my lord,
So what?
police is not.
Huh?
Maybe, my lord. Seeing the coming of the police in the village, all villagers left their house.
But no, then it says police examined me. You see, if all the villagers had gone and met the police, there was no requirement of the police to examine him. Unless anyway. Okay, then
W3, my lord, is inconsequential, my lord.
what does it say?
Page 12, my lord, I know the informant and the two accused. I knew the deceased. The incident took place in 2017. On the day of occurrence, I heard that Suman Devi had died. Then PW4, my lord. She says that, my lord, she has not present on that date and she has deposed whatever she has heard from the villagers, my lord. I do not know the informant. I knew the deceased. I know the accused. I do not remember the date on which the incident took place, but it took place sometime 2-3 years ago. At the time of the incident, I was not at my village. I was at village so-and-so for my mother's treatment. I returned to my village on the date of occurrence. After returning to my village, I came to know from the villagers that the deceased had committed suicide. That accused Birendra Chauhan, the husband of the deceased, and so-and-so, the father-in-law of the deceased, had not informed the police about the suicide and burned the dead body instead. I learned that for that reason, police arrested both of them and took them away. I am not aware if any villager was present at the time when the deceased was burned. Today, I have deposed in the court whatever I heard from the village. Then, my lord, PW5, my lord, I do not know the informant. I knew the deceased. I know the accused. I do not remember the date on the incident took place, but it took place some 2-3 years back. At the time of the incident, I went to Morigaon to see my ailing Bordeuta. I returned to the village 12 days after the death of the accused. While I was still at Morigaon, my wife informed me over phone that the deceased had committed suicide by hanging herself. My wife said that the police had arrested the accused person in connection with the case. I know only this much about the incident. I do not know who among the villagers were present. Now, PW6 is very important.
Who is he?
He's a neighbor, my lord. He's a village.
Yes.
I know the informant and the accused person. I knew the deceased. The incident took place on 21st of February 2017. Around 7 a.m. on the date of the occurrence, I was going to a shop to buy biscuit. The house of the accused person is situated at a little ahead of the shop. At that time, accused Jakari Chauhan was sitting outside his house. Having seen him, I asked him how he was and he replied that he was fine. Just at that time, I heard uproar from the inside of the house and someone had hanged herself, oblique himself, and then accused Jakari and I entered the house. After that, we saw the deceased Suman Devi was hanging by her sari around her neck in a room where paddy was kept. Then accused Jakari Chauhan pushed the dead body upwards by holding its feet and asked me to cut the sari. Seeing a down lying nearby, I cut the noose of the sari. Thereafter, accused Jakari laid the dead body on the ground. Although the deceased's fingers and toes were found moving for a little while, later the deceased became still and died. The accused person then burned the dead body. After the dead body was burned, police got the information and came to the place of occurrence. Now, this is important, my lord. When I went to the place of occurrence, accused Birendra Chauhan was not present there, but he came some 5 to 6 minutes after the dead body was brought down. In cross, my lord, I visit the house of the accused person on occasion. I did not see any quarrel between the deceased and the accused person. I just know that the deceased committed suicide. At the time of burning the deceased, some 30 to 40 villagers were present there. The village headman was also present there. And the IO has said that he could not find the village headman to examine. Even the headman was not examined. Now, this is the SI of police, man, of PW7, the IO.
Ayo.
IO.
Yeah.
On 21/2/2017, I was officiating as the second officer of Kokolia police station. That day, by lodging an ejahar with the PS, a person from the name by the name of Kumar Chauhan informed that on that day itself, Birendra Chauhan had killed his wife Suman Devi, who was his Kumar Chauhan's niece, and had burned the dead body. That day, as the officer in charge of the PS was out of station for training, I registered so-and-so case number so-and-so under 302 and 201. and I myself took the charge of investigation. Exhibit 1 is the Ejahar and exhibit 1, 2 is my signature there. I received the Ejahar at 3 p.m. and I questioned the informant at the PS itself. Thereafter, at 3:15 p.m., I, taking along the informant and the staff, proceeded to the place of occurrence. I questioned the people I found at the place of occurrence, and I came to know from them that on that very day, the neighbors had heard a quarrel taking place between deceased Suman Devi and her husband Birendra Chau. That after some time, the neighbors had gone to Birendra's house upon hearing hue and cry at the latter's house. That then the accused persons told the neighbors that Suman Devi had committed suicide, that the neighbors had seen the dead body kept laid at the courtyard of the accused house, that immediately accused Birendra and his father Jokari had lifted the dead body up into a bullock cart and then taking the dead body onto a sugarcane cultivation, then burnt it. Thereafter, I prepared a sketch map of the place of occurrence and clicked photo of the place where the dead body was burnt. Exhibit 2 is the sketch map and exhibit 2.1 is my signature there. Exhibit 3 is the photograph of the place where the dead body was burnt. I could not find anything except ashes at the place where the dead body had been burnt. Thereafter, I recorded the statements of the witnesses and started searching for the accused. After that, I apprehended accused Birendra Chauhan alias Vijendra Chauhan while he was hiding in a sugarcane field near the place where the dead body was burnt. Then I brought Birendra to the PS, but I could not trace his father out. I questioned the accused in the PS itself, and finding evidence of his involvement in this murder, I arrested him. On the following day, on 22/2, I came to know from a secret source that accused Zakari Chauhan came to Rajapathar market, and soon after getting this information, I along with staff went to Rajapathar market, apprehended the accused and brought him to the PS. Thereafter, I questioned Zakari, and finding evidence of his involvement in the murder, I arrested him too. On the same day, I forwarded both the accused to judicial custody. On 16 March, I made a prayer to the Honorable Court to record record statements of witnesses Rajesh Chauhan and Baburam Horizon under 164. And accordingly, the court recorded the statements of both the witnesses. Thereafter, finding sufficient incriminating materials of killing Suman Devi against accused Birendra Chauhan and Zakari Chauhan, I submitted the charge sheet on 30th of April 2017 against the two accused persons for commission of offense under 302, 201, and 34 IPC. Exhibit 4 is the charge sheet and exhibit 4.1 is my charge signature. I did a cross-examination. I did not make a prayer to the Honorable Court to record confessional statement of the accused. The witnesses, namely Baburam, Rajesh Chauhan, and Umila Devi, stated that they learned that a quarrel had taken place between the deceased and accused Birendra Chauhan on the day of the occurrence, and that they heard Suman Devi screaming. After some time, the dead body was kept laid on the courtyard of the house of the accused. The houses of the three witnesses are situated near the house of the accused. Although these three witnesses did not witness the quarrel, they had heard hue and cry and sound of quarrel. As per the statements of the neighbors of the accused persons, the dead body was seen at the courtyard of the house of the accused after the accused person had killed the deceased. It was known after questioning the witnesses that no villagers, except the two persons, was present at the time of burning the deceased. Although I went to record the statement of the headman of the village of the accused persons, I could not do so as I did not find him. First, is it possible that the IO could not even find the Gaubura Malo? And the statements of these persons, which he relies upon, Baburam Horizon, Rajesh Chauhan, and Urmila Devi Malo, they have stated entirely different version before the court, Malo.
Let us see what is their, what 164 statement, what is their
164 statement lodgeable by 53 Malo. 53 Malo.
53, this is 164 statement of
PW4 Malo.
what does it say?
Whatever is stated in 164 is not stated in evidence, my lord. And these things are also not put to the appellant in 313, my lord. My name is so-and-so, age 30 years. I know Sri Vijender, who happens to be my neighbor. One day in the month of February 2017, when I was coming out with my wife at about early in the morning, that is about 4:30 for nature's call, then my wife heard some screaming and shouting, crying of Vijender Chauhan's wife. and told me that maybe Vijender was torturing his wife. So she hurried to go to the Vijender's house just because that she was my neighbor. So my wife went to Vijender's house and asked him not to do so. In the meantime, Vijender pushed my wife, touching her shoulder. So I immediately rushed to Vijender's house and asked him why she touched other women. It's a bad, I mean, this is the translation, my lord. But Vijender, instead of cooling him down, he started quarreling with him. Then my wife pushed me back to my house, saying not to on their family matter. On the same day, after a few minutes, I left for my parents' house, leaving from my house, village, at about 2 kilometers away. When I came back, parents' house, I came to know that Vijender's wife is dead. And Vijay and his son took the dead body to so-and-so, Samshan for cremation. After that, as I know, police came to my village and took Vijender along with them. Next day, his father was also arrested by the Popolia police. That's all. Your Honor.
And what about PW2's?
PW2, page 55, my lord. My name is Baburam Horizon, age 65 years, cultivation. When it was about 8 AM morning, February 2017, I do not remember. I am a sick person, so when I was at home taking rest, I show Vijender's father and Vijender ride a bullock cart towards sugarcane garden carrying one dead body in a bullock cart. I was observing from my house. I only can say that both father and son was carrying the dead body of Vijender's wife to
So
sugarcane
have
garden.
this confessional statements been exhibited?
No, my confessional statement, there is no confessional statement.
I mean, the statements of, what's it was statement of PW4 and 2?
No.
Not exhibited.
And I'm not, the accused is not even confronted with those men in 313. No, sir, question number 9. Except question number 9, my lord, everything is a denial.
313 you mean?
313, my lord, starts at page 24.
Question 9.
9. Question number 9, answer is
This is
yes.
who's
This is my learned friends, the appellant word whom I
that is
learned.
the husband.
The father-in-law, my lord.
First one is husband matter. Page 20,
Oh, no, ठीक है.
27.
26, first one is me, my lord, Virendra Chauhan.
Page number.
And page 26
Page
is
26 and 29. 26 is the appellant in item number 9. And 9 is the appellant in item number 8.
no, 26, not 26.
26.
Then page 20.
Starts at 27, is 29, my lord, the question.
Both question number 9.
Both
Yes.
question.
Same word.
Same version, my lord. Yes, I am fully innocent. The deceased committed suicide by hang while I was in the paddy field, which is away from the house. On advice of villagers, including local Kambura, immediate after occurrence. dead body
But
of-
then this 313 is not in conformity with the evidence of PW6.
Only insofar as the appellant in
The father-in-law.
father.
Oh.
The other is in sync, my lord, because he says the PW6 says that he came after 5-6 minutes.
Okay, okay, there is one aspect. Your wife died due to suicide. Why didn't you call her parent?
It is not a case of suicide. No.
Huh?
It is not a case of prosecution's case is not of suicide. No.
You burned the body without calling for the parents of the
My lord,
the
that
wife.
part I cannot say, my lord, whether the parents are alive or not, that much also I cannot say, my lord. Nothing is discernible from the evidence.
Huh?
Police was not informed.
Police not informed. Parents not informed. No one was informed.
No, the villagers knew, my lord. It is not that secretly the father and son went and
Mr. Council, come on. Villagers are not more important than the parents of the bride.
but my lord, there is nothing on record to show that even the parents are alive, my lord. We do not know.
There is nothing to show that they are dead also.
There is nothing to show.
That-
Being the amicus, my lord, I will not be in a position to have that information, my lord, whether the parents are alive or not. Because nothing has come on record that the parents were
And,
alive.
In all probability, you did not marry an orphan also.
My lord, that is
When did you marry?
1 year back,
1 year back.
1 year. My lord, had it been a case of abetment of suicide, the case of the prosecution, then my lord, the presumption and everything would have come. But the prosecution case is of murder, my lord. And going by PW6, my lord, it could not have been murder. I'll come to 201, my lord. Destruction of evidence part is separate, but it could not have been murder. Because PW6 is not declared hostile, my lord. Lordship will kindly make a note. The prosecution realized it is prosecution's witness. Had PW6 been declared hostile, then we could have understood. But the prosecution relies on PW6. Evidence is clear, my lord. He was waiting, father was outside, went inside. It is the father who lifted the body and the son came 5 to 6 minutes thereafter.
But in your 313, you have stated that you were in the field,
Yes,
but that is not what PW6 says. PW6 says that you were just outside the house. And
yes,
when you
that is,
heard.
that is with regard to my lord. That's with regard to the father. But with regard to the son, my lord, that is corroborating, my lord. He came 5 to 6 minutes thereafter. PW6 could not have known where he was. But he came 5 to 6 minutes later. He could not have, it cannot be murder 302, my lord. Under no circumstances it can be 302. Because she was alive when the body was brought down. So where is the act, my lord? The act of murder, man. At the cost of repetition, my lord, had it been a case of abetment of suicide, I could have understood, my lord. But the charge is of 302. You have to prove it, establish it beyond all reasonable doubt. And lordship has seen the evidence. And my lord, in the judgment, my lord,
Reasoning.
161 statements have been relied upon, my lord. Lordship, it is settled on 161.
Where?
Para 17, page 41,
Page 41.
41, para 17. On the basis of which evidence of 6 is discarded by.
Page 41.
Page
Para.
41, para 17, my lord.
Real paragraph 7.
Lordship will also have a look at 14, my lord. May evidence be chronological. My lord will also kindly see page 43, my lord, where the learned judge, my lord, presumes, my lord, just before the portion of order, my lord, page 43,
Yes.
just above that, my lord. It is also evident that the deceased was got married to accused so-and-so 1 year ago from the date of occurrence. In view of the discussions made above, it can safely presume that the accused person. A presumption will not come in 302. And to establish the charge of 302, my lord, the prosecution has to have a story, my lord, how it has happened. How did I kill? My lord, only one judgment I'd like to rely upon, my lord. 2018 3SCC page 313, my lord. I'm just handing over. This was a case of 498A and 201, my lord. Where of course, slightly factually different in the sense, my lord, that the body was cremated in the presence of the parents, my lord.
Parents of the deceased.
Parents of the deceased. And 498A, the accused was acquitted, my lord. But 201, the High Court find them guilty. The apex court has said no, cannot be.
Para.
A small judgment, my lord.
No, not The small judgment comprising of how many pages?
5 to 6 pages, my lord.
Yeah,
Three
more than
21.
5 to 6 pages, much more than that.
Here,
It starts from 3,
no, my lord, judgment starts at page 315,
3 or 5 to 21.
18 to 21, my lord.
So you're going to
17, my lord. Lordship will kindly come to page 320,
Ah.
para 17. Thus, the only ground for maintaining the conviction under 201 is that the appellant did not give intimation to the police of the unnatural death and that no postmortem was conducted. We are afraid the High Court is not justified in maintaining the conviction under 201 only on the ground that no communication was given to the police and that the postmortem has not been performed. The trial court has taken note of the fact that the father of the deceased and her brother, who is a doctor, had attended the last rites of the deceased and neither of them had any complaint of suspicion at that time of the commission of any offense. The Sessions Court has also taken note of the suicide note left by the deceased wherein she had taken the entire blame on herself. Yet the court has taken the view that from the consideration we have extracted from para 16 of the Sessions Court judgment that the deceased might have been in a state of depression, having remained alone for most of the time and amounted to torture. The appellant has been acquitted of the offense under section 498A by the High Court, and rightly so. The prosecution has also not been able to satisfy the ingredients under 201 IPC. Neither the Sessions Court nor the High Court has any case that there is any intentional omission to give information by the appellant to the police. It is also to be noted that prosecution has no case under section 202 IPC against the appellant. This is another case is relied upon. 19 is important. As held by this court in case of so-and-so, the mere fact that the deceased allegedly died in an unnatural death could not be sufficient to bring home a charge under 201. Unless the prosecution was able to establish that the accused person knew or had reason to believe that an offense has been committed and had done something causing the offense of commissioning of evidence to disappear, he cannot be convicted. Now, where is the prosecution case, my lord? First and foremost, my lord, there has to be a prosecution story that this has happened. Because there is some inconsistency whether it was taken on a
In
plan.
this case, during the last rites, the relatives of the deceased was there.
Was present. I've stated at the beginning, my lord, that is the distinction. Here also, my lord, the relatives may not have been present. But it was in the presence of the villagers. It is not that secretly in the night, middle of the night, I have taken away, secretly burned, destroyed evidence. No, my lord, it was done in the open. And what the lordship has right, my lord, the parents were also never brought, my lord, by the prosecution.
Neither by you.
Well, I am not required to do that, my lord.
Yeah, you are supposed to inform them.
That is different, my lord. Whether I'm supposed to inform the police, the prosecution has not brought them as witnesses, my lord. The presumption will not come in 302. I don't have to rebut any presumption on the 302, my lord. The uncle also doesn't say that the parents are alive.
Yes, anything else?
None of my learned friend would like to add something.
So far as presumption is concerned, my lord, I'd like to place two attachments, my lord,
Okay.
on when can that presumption can be drawn, my lord. Para 25 to 28.
Para?
Para 25 to 28. Citation is 73 to SCC 808, my. 80,
Para?
25 to 28, my lord.
Yes.
Because from the judgment, my lord, it is all, all along provident that witnesses, those are those has given deposition, my lord, all the other hearsay evidences, my lord. No one has seen the incident, my lord. Neither it can be ascertained from their evidences. These are the two persons, none other than any person is involvement in this case, my lord. So in fact, it has to, when two views are concerned, my lord, so if it is something doubtful, then it has to be discarded, my lord, and it goes in favor of the accused appellant.
Yes. That's all.
That's all.
He was not declared.
161 statements, what does it say? It's in Assamese. But what does it say? I'll have to, because even, what does it say? Huh? You translate because otherwise I'll only be nodding my head, pretending to understand. Okay. Yeah, so he came to the place of occurrence. Place of occurrence after hearing of the death. And they cremated it without the villager.
It is not declared hostile. It's a prosecution witness. Neither it was proved.
Then no, but then to say that he cannot be believed, won't he have to be, won't he have to be confronted with
He has to be declared.
For disbelievable, he has to be
Hostile
hostile person.
So if he's not confronted with it, then we cannot go to the next step.
No, no,
Not
no.
hostile, he's not hostile, but in fact,
Some
no,
contact-
the thing is that if he is not contradicted with the previous statement, can we say that he is not a reliable witness? One zero six. That is what, and no, but then the police also is not doing their job.
Yes, ma'am.
Nothing has been brought on record,
Were the
madam.
parents alive, or who are their relatives, what not? Who was that lady who informed the informant? Not, no motive.
No more.
We can bring it, but how will it help you? But what about the later judgments which say that, the judges of 57, but what about the later judgments which requires, which requires you to confront them with the previous statement?
It's not exhibited.
Uh, okay. That's all. I don't think 57, the judgment will help you. Okay, right. And Miss M. Burman, amicus curiae in criminal appeal J 87/2020. And Mr. N. Deca, amicus curiae in criminal appeal J 88/2020. Also heard Ms. S. Jahan, additional PP for the state. The two appeals have been filed against the impugned judgment dated 8/1/2020. Passed by the 8/1/2020 and eight one 2020 / 22/1/2020. Passed by the learned sessions judge from a Karbi Anglong. In sessions case number 76/2070, by which the appellants have been convicted under sections 302/201/34 IPC. And they have been sentenced to undergo rigorous imprisonment for life with a fine of rupees 2,000 comma, ID RI for 3 months under section 302 IPC. And to undergo RI for 1 month, 1 year. And with a fine of rupees 500, ID SI for 1 month under section 201 IPC. Mustafa. On being found guilty of having committed murder of the on the deceased how? By hanging of her. By hanging her with a sari. By hanging her. By hanging by hanging the wife of the appellant in criminal appeal J 88/2020. With a sari. This para. The appellant in criminal appeal J 87/2020 is the father of the appellant in criminal appeal J 88/2020. While the deceased is the wife of the appellant in criminal appeal J 88/2020. The prosecution story in brief. Here, prosecution case in brief is that an FIR dated 21/2/2017 was submitted by the uncle of the deceased who has been arraigned as prosecution witness number 1. In the FIR, it has been stated that the appellant in criminal appeal J 88/2020 had killed his wife Suman Devi on 21/2/2017 by assaulting her and burning the dead body. It is also stated in the FIR that the deceased was the niece of the informant PW PW1. In pursuance to the FIR, Bakalia PS case number 13/2017 under section 302/201 IPC was registered on 21/2/2017 at 3 p.m. PW7, who is the IO, then took up the investigation of the case and on finding a prima facie case against the appellant under section 302/34 and section 201/34 IPC, file a charge sheet against them. The learned trial court thereafter framed charges under section 302/34 IPC and section 201/34 IPC against the appellants, to which they to which they pleaded not guilty and claimed to be tried. In the trial proceedings held by the learned trial court, 7 prosecution witnesses were examined. After examination of the appellants under section 313 CRPC and after hearing arguments, the learned trial court came to a finding that the appellants were guilty of the offense under section 300 IPC and 201 IPC. And they were accordingly convicted under section 302 IPC, 302/34 IPC and 201/34 IPC. Next paragraph. The learned counsels for the appellants submits that the impugned judgment passed by the learned trial court has to be set aside inasmuch as there is no evidence to show the appellants being involved in the to show any involvement of the appellants in the death of the deceased. They further submit that the finding of guilt against the appellants has been made by the learned trial court on the basis of presumption and not on the basis of the evidence adduced by the prosecution witnesses, some of which points to the innocence of the appellants. In this respect, they have relied upon the evidence adduced by as PW 6.
6 months.
Who has not been declared to be a hostile witness. They also submit that though PW2 and PW4 had given statement under section 164 CRPC against the appellant, the said statements made under section 164 CRPC had not been exhibited during the trial proceeding. Further, the PW2 and PW4 were also not confronted with the statements made by them. No, were not confronted with the contents of the statements allegedly made by them under section 164 CR. They also submit that the trial court has also relied upon the statement made by PW6 under section 161 CRPC to come to a finding that the appellant were involved in the death of the deceased. which is not permitted as per section 25 of the Evidence Act. Is it 25?
Yes.
In support of the submission that the learned trial court could not be allowed to make any finding on facts on the basis of presumption, comma. They have relied upon the judgments of the apex court in the case of Dash versus Dash, 2018, 3 SCC 313 and 1973, 2 SCC 808. They have accordingly paid for setting aside the impugned judgment and acquitting the appellants from the charges framed against them. On the other hand, Ms. S. Jahan, the learned additional PP, submits that what do you submit? Make a submission. on it. Submits that there is a discrepancy between the statement made by PW6 under sections 161 CRPC and the testimony given before the learned trial court, and his testimony given before the learned trial. So although the contradiction made in the above two statements were not proved. No, although the contradiction with regard to the statement under section 161 and testimony during evidence was not proved, comma, what? The fact remains that there was a contradiction. There was a contradiction made by PwC. As such, in the interest of justice, the PW6 cannot be said to be a reliable witness. And keeping in view the circumstances of the case, and there was no infirmity in the conviction of the appellant by the learned trial. That's all. Huh? She also, full stop, she also submits that the circumstances of the case all point towards the guilt of the appellant in the death of the deceased. Full stop. Further, there is nothing to show that the appellant had attempted to inform the relatives of the deceased with regard to the death of the deceased and that the cremation of the deceased had been done hurriedly within 2 hours. Within 2 hours of the death of the deceased. That's all. Accordingly submits that the impugned judgment should not be interfered with. We have heard the learned counsel for the party. The evidence given by PW1, who is also the informant who submitted the FIR to the police, shows that he had only heard about the death of the deceased from one woman, from one person in the village who has not been identified. He also, his PW1 statement, testimony, that he had also been told by one woman that the appearance had killed the deceased is also hearsay, as the said woman has not been identified by PW1 or any of the witnesses, or any of the prosecution witnesses. The evidence of PW2, who is a neighbor of the appellant, is that on the day of the occurrence at about 7 a.m., while he was in his house, he heard shouting in the house. He heard shouts, not shout, he heard shouts in the house of the appellant. He did not immediately go to the appellant's house. At 7 a.m., at 7 a.m., PW2 found the appellant in criminal appeal J87/2020 near his house, and on asking him, the appellant told him that the deceased had committed suicide with a sari at about 7 a.m. in their house. PW2 also states that at about 9 a.m., he saw the villagers and the appellants taking the dead body of the deceased in a plank for cremation towards the sugarcane field. In his cross-examination, PW2 states that he never heard any quarrel taking place between the appellant Birendra Chauhan and his wife, and his deceased wife. He also states that about 10 to 12 persons of the village took part in the cremation of the deceased. Next para. PW3 in her testimony states that she had heard that the deceased had died from villagers on having committed suicide. PW4 in his evidence states that he was not in the village at the time the incident occurred. He only came to know that the deceased had committed suicide from the villagers. He had also heard that the appellants had not informed the police about the suicide and burned the dead and cremated the dead body instead. In his cross-examination, he states that he was not aware if any villager was present when the body was cremated. Next para. The evidence of PW5 is that he was not present at the time. Was that he was not present at the time the incident occurred, and that he returned to his village 12 days after the death of the deceased. He states that he had been informed by his wife over phone that the deceased had committed suicide by hanging herself. In his cross-examination, his PW5 states that he did not know who among the villagers were present at the time when the body was cremated. Must be a very small village or what? Influential person. Maybe. Ah. There's, there's someone peeping in. Face right next to the glass. Maybe wanting to take a nap in AC room. Anyway, right. The evidence of PW6, who is a neighbor of the appellant, is to the effect that he knew the appellant and the deceased. While going to a shop to buy biscuits at around 7 a.m. on 21/2/2017, bracket Tuesday, he saw the appellant Jakari Chauhan, bracket father of Birendra Chauhan, right, sitting outside his house. While asking him how he was, and while being replied that he was fine, he heard an uproar from inside the appellant's house that someone had hanged. But how can you hear an uproar when no one else is in the house? How can there be an uproar when someone hangs herself? But how can there be an uproar? There cannot be an uproar. Someone hangs herself, you hang yourself, you'll be gasping for breath. You cannot shout or anything. And uproar means what? Noise. And voice, noise made from your voice box. Uproar cannot be, picking something or something. And you heard what I think? While being replied by the appellant that he was fine, brought from inside the house, that someone had hanged that head house. I think this translation is wrong. This is the original version. I don't think. How can it cannot be? So PW6, the evidence. I think this translation is wrong.
Records will be here, madam.
Just give the record.
PW6, the original record.
Just read.
PW six.
Ah.
No, someone shouted that someone is hanged.
Okay, okay, so there are other people inside the house.
Let's see.
Oh, there were other family
That is
members inside the house. Okay, okay. So, what am I saying? In the house that someone had hanged, that someone had hanged herself, that someone had hanged herself slash himself. Ustad. On entering the house, PW 6 saw the deceased hanging by her sari, which was around her neck, in a room where paddy was kept. The appellant Jakari Chauhan thereafter held the dead body and pushed it upwards by holding the feet and asked PW6 to cut the sari. Seeing a dhow lying nearby, PW6 cut the noose of the sari. Thereafter, the appellant Jakari Chauhan laid the dead body, laid the body on the ground. Although the fingers and toes of the deceased were moving for a little while, the deceased later died and became still. The appellants thereafter burned the dead body. They're not burnt, cremated the dead body. After the dead body was cremated, police came to the place of occurrence as they had received information of the same. PW6 also states that when he went to the place of occurrence, the appellant Birendra Chauhan, bracket, wife of deceased, husband of the deceased, bracket, was not present, but he came to the place of occurrence 5/6 minutes after the dead body had been brought down. Subpara. In his cross-examination, PW6 states that he visited the house of the appellant occasionally, and he did not notice and he did not see any quarrel between the deceased and the appellant. He also stated that the deceased had committed suicide, and at the time of cremation, some 30/40 villagers were present, besides the village headman. Next para. Not next para, just there. Next para, next para. The evidence of PW 1 to 5 are basically hearsay evidence. However, the evidence of PW 6 does not give any indication of the involvement of the appellants in the death of the deceased. And in fact, only points towards the deceased having committed suicide. Though it is surprising that the appellants did not inform the relatives of the deceased with regard to the death of the deceased and the fact that the cremation took place just 2 hours, just within 2 hours of the death of the deceased, comma. There is nothing in the evidence to show that the deceased was having any living parent or other relative besides PW1. There is nothing in the evidence of the IO PW7 to show that he had made any attempt to ascertain whether the deceased was having any living parents or other relatives besides PW. Though the though there is no though the circumstances in cremating the dead body at such a short notice is suspicious, comma. We cannot decide this case on the basis of suspicion and speculation. Further, there is nothing to show that the evidence of PW, that the testimony of PWC is not reliable. Though PW6 in his statement under section 161 CRPC had stated that he came to the place of occurrence after hearing of the death of the deceased and that the appellants had not called the villagers at the time of cremation of the dead body, comma. The PW6 had not been confronted with the contents of his statement made under section 161 CRPC. Huh? 145. Uh. Section 145 of the Indian Evidence Act 1872 provides that a witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matters in question, without such writing being shown to him or being proved, but if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting it. What was that judgment? 19 with regard to this. Yeah, VK. Uh, I don't know. In this respect, uh, we may take, we may take, we may, in this respect, the apex, the Supreme Court, in the case of BK Mishra and others versus State of Uttarakhand, reported in 2015, 9 SCC 588, has held that a witness should be confronted with his previous statement made before the police under section 161 CRPC to contradict his testimony. However, in the present case, no such. How in this case, PW6 has not been confronted with his previous statement made under section 161 CRPC. And as such, there is nothing to show that PW6 is not a reliable witness. Next para. PW7, who is the IO of the case, in his evidence has stated that on questioning the people at the place of occurrence, he came to know that the neighbors had heard a quarrel between the deceased and her husband Birendra Chauhan. And on hearing a hue and cry in the appellant's house, the neighbors were told that the deceased had committed suicide. The appellants had thereafter immediately taken the dead body in a bullock cart to a sugarcane field and burnt it. He also states that after recording the statements of witnesses, he started searching for the accused persons. He apprehended the husband Birendra Chauhan while he was hiding in a sugarcane field near the place where the body was burnt. And no, first up. However, he could not trace out Jakari Chauhan, father of Birendra Chauhan. On coming to know from a secret source on 22/2/2017 that the appellant Jakari Chauhan had gone to Raja Pathar market. He apprehended Jakari Chauhan from the market. He also, the PW7 also states in his evidence that he made a prayer to the court to record the statements of PW2 and PW4 under section 164 CRPC, which was accordingly recorded. Thereafter, finding sufficient material incriminating the appellants for the death of the deceased, charge sheet was filed. In his cross-examination, PW7 states that after questioning the witnesses, he learned that no villagers except the two appellants were present at the time of burning of the body of the deceased. Further, he could not record the statement of the village headman as he could not find him. Next para. The evidence of PW7 is based upon the statements made by villagers. However, the evidence given by PW by all the prosecution witnesses does not support the evidence given by PW7. PW2 and 4 had apparently made statements under section 164 CRPC, which were exhibited. Which were not were under 64 CRPC before the judicial magistrate, before a judicial magistrate. However, the judicial magistrate who had apparently recorded the statements made under section 164 CRPC has not been made a witness and has never been examined by the learned trial court. Further, the statements of PW2 and 4 made under section 164 CRPC have also not been exhibited before the learned trial. The PW2 and 4 have also in their testimony before the learned trial court, not made any mention with regard to the contents of the statements allegedly made by them under section 164 CRPC. And neither has it found any place in their testimonies before the learned trial court. First up. As such, the statements made by PW 2 and 4 under section 164 CRPC is not admissible in evidence. First up. Next paragraph. The examination of the appellants under section 313 CRPC shows that they have denied any involvement in the death of the deceased, except with regard to their explanation that, no, but not except, by stating that the deceased committed suicide by hanging while they were in the paddy field away from their house. Further, the body was cremated on the advice of the villagers and the local and the village headman. And the village headman. Both. On considering all the above facts, comma, we are unable to find evidence to prove the involvement of the appellants in the death of the deceased. Next paragraph. On considering the impugned judgment passed by the learned trial court, comma, we find that the learned trial court has placed importance on the fact that there was no evidence recorded showing that the relatives of the deceased were informed about her death before cremation of the dead body. Further, further, the learned trial court appears to have given importance to the statement made by PW6 under section 161 CRPC. As he had stated in his statement under section 161 CRPC that on coming to the house of the appellants at 8:30 AM, after hearing of the death of the deceased, he came to know that no villager was informed about the death of the appellant, of the death of the deceased, and that the appellants had taken the dead body in a bullock cart for cremation. Full stop. Besides the above, the learned trial court in the last sentence of para 21 has stated as follows. Inverted comma. In view of the discussion made above, comma, it can safely presume that the accused persons were the culprits who caused death of the deceased. Inverted commas. Full stop. The above clearly shows that the finding of guilt against the appellants has been made by the learned trial court on the basis of presumption. While the law requires that a person should be found guilty beyond all reasonable doubt. It has been clearly laid down. It has been laid down. It has been clearly laid down by the Supreme Court in the case of Dash and Dash that a person cannot be convicted on the basis of presumption and suspicion, no matter how grave the suspicions. Next paragraph. In the case of Dinesh Kumar Kalidas Patel, Supra. No, no. Acha, one thing. No, next, no, next. Correct. In that view of the matter, in view of the above reasons, comma, we are of the view that the the appellants cannot be set. We are of the view that the charge under section 302/34 IPC cannot be said to be proved beyond all reasonable doubt. Whatever I said, 302/34 IPC beyond all reasonable doubt. As such, on this count, the impugned judgment is set aside. Next para. With regard to the question whether the finding of guilt under section 201/34 IP is sustainable, comma, it would be profitable to refer to the decision of the learned Supreme Court, Honorable Supreme Court, in the case of Dinesh Kumar Kalidas Patel, Supra. Wherein Uh, what have I said? Wherein it was held that maintaining conviction under section 30 under 201 was not justified on the ground that no communication was given to the police and that post-mortem report and that the post-mortem had not been performed on the dead body. So stop. In the case of Hanuman versus State of Rajasthan, 1994, supply to SCC 39, the apex court has held that the mere fact that the deceased allegedly died an unnatural death could not be sufficient to bring home a charge under section 201 IPC. Unless the prosecution was able to establish that the accused person knew or had reason to believe that an offense had been committed and had done something causing the offense of commission of evidence to disappear, he cannot be convicted. So after that 201 IPC put full stop, then unless we'll start separately. In the case of Dinesh Kumar Kalidas Patel Supra, the last rites had been performed in the presence of the father and the brother of the deceased. However, in the present case, there is nothing to show that the appellants had made any attempt to inform the relatives of the deceased with regard to the death of the deceased, except for PW1. The police had also not made any attempt to communicate with any relative of the deceased with regard to her death. However, we cannot lose sight of the fact that PW1 had been informed of the death of the deceased and that PW1, who was the uncle of the deceased, had been informed of the death of the deceased. Okay? I think PW1 is the uncle.
Yes.
As such, PW1 could have easily communicated, could have easily informed the other relatives of the deceased, including her parents, if the parents of the deceased were still alive. Full stop. There is no evidence to show that the parents of the deceased were alive, or that no attempt had been made to communicate to them by PW1. Full stop. As such, we are of the view that the non-communication of the death of the deceased to the other relatives, who may be alive, would not could not cause any prejudice to the appellant with regard to the circumstances involving the death of the deceased. Full stop. Further, as the Honorable Supreme Court in the case of Dinesh Kumar Kalidas Patel Supra has held that conviction under section 201 IPC would not be justified on the ground that no communication was given to the police or that post-mortem had not been performed. Yes, because the deceased had died an unnatural death, comma. We are of the view that the same would not be sufficient reason to bring home a charge under section 3201 IPC. In that way of the matter, we are also of the view that the appellants cannot be found guilty of being guilty of the charge under section 201/34 IPC. In view of the reasons stated above, we are of the view that the impugned judgment is not sustainable. The impugned judgment and order, the judgment dated so and so, passed by so and so is hereby set aside. The appellant, the prosecution not having not having been able to prove the guilt of the appellant beyond all reasonable doubt, comma. The appellants are accordingly acquitted of the charge framed against them under section 302/34 IPC and 201/34 IPC. The state respondent is accordingly directed to release the appellants from judicial custody immediately. The appeals are accordingly allowed. Send back the LCR. Next, in view of the in appreciation of the if not wondering someone. Anything else? Now.
Problem.